Yes.
Yes, may please, your lordship. Lordship, may I pray for listing of a motion matter tomorrow, your lordship?
May I please your lordship? Lordship, this is with regard to item number 15 and 16. We are in the process of giving our no objection certificate. The clients will be engaging some other clients, some other counsel. So your lordship may kindly fix this matter after a week, enabling them to engage some other counsels, your lordship. We will be returning the brief today itself.
Why the matters come up by order?
Lordship.
No. When a matter reaches. Yes.
May I please, Lordship? Lordship, I'm proprietor of College of Aeronautical Engineering, Guwahati. It is a very urgent matter. I have filed a brief petition against the Union of India to save my college. So urgently, it may be heard at 2 o'clock, Lordship. It is very, very urgent. Otherwise,
You
it
have
will-
filed a petition.
Yes, Lordship, just now.
You have to give a mention memo.
Lordship. Deeply obliged.
What is the urgency?
Lordship, the college, Union of India, I mean, that is Secretary of Civil Aviation. They are approving the shifting of my college at Gunupur, which is very illegal. I'll bring it before your lordship.
Okay.
Deeply obliged, lordship. At 2 o'clock. Deeply obliged.
Lordship, I'm praying for listing of an item in the admission column, Lordship, on Monday.
Why?
Lordship, it has been alleged.
Change to?
Lordship, it has been alleged, we for the respondents, it has been alleged that we are carrying out illegal construction work in the premises of the petitioner. And it was last listed in the month of July, wherein the court had ordered within a week, the authorities would let them know about the demarcation order. But the matter has not been listed and we haven't been intimated regarding the same.
When is it?
Lordship.
May I please beg to mention item number 22, my lord, with the item number 22 with the consent of the other side. Can you take up this matter after 2 weeks as the
22 is tied with 21. 22.
22, my lord.
22 is tied with 21. What is the matter about?
It pertains to some documents, but that has not been furnished by the revenue board, my lord.
You've taken the consent of the other side.
Other side, my lord.
Okay. Item number 21 and 22 will listed on 10th of September.
Obliged.
Wait, please, your lordship. Can I pray for a listing of a case tomorrow, my lord?
For what?
It's regarding tender matter, my lord, and it's opening
Motion?
on Saturday, my lord.
Okay.
I'm with this.
For motion item 1.
May I please, Lordship, kindly pass over the matter for the time being.
Why?
Our senior is stuck in the traffic.
Where is the senior?
He is
Busy.
coming, he is on leave.
You've got a copy?
Yes, my lord. I got instructions also.
Yes. Take it up after some time. Before the motion finishes.
Item 2.
Well, the connected matter is item number 36, sorry. The lordship would recollect on last occasion, lordship indicated, because we never made any prayer for consideration of a representation at the hands of the revenue authority regarding, that is how this press petition has been filed, Miller. All that we want on the ground that it's a non-cadastral village, my lord.
This is connected with 36, na?
36.
It's 46 and 47 over 88.
You have not challenged the non-granting of the NOC.
Yes, last time we did not.
Ah.
If your lordship would kindly come to page number 46, my lord. They have acknowledged also of the item number 2,
40.
page 46. your application for NOC for same class has been submitted successfully on 30/11/22, and your acknowledged number is so and so. And the application is at page 47 below. Prayer for issuing land lease permission. Lesser so and so, lessee so and so, in reference to the above subject, with the above applicant agreed to lease a plot of land measuring 7 biga, so and so covered by so and so, for which your permission is necessary. Therefore, we request you to issue necessary permission to lease the above mentioned land. Now, this is still pending.
Okay, we issue a short notice.
Yes,
Yes, who is representing whom?
For the revenue department.
Why is the forest made a party here?
because forest is the original authority, my lord, against from whom, like, it's a, my lord, stone quarry. It's a formal party.
Forest land. I issue notice making it returnable on, I'll finish it up on next date.
Yes.
It will instruction, because this will go with the other one. Issue notice making it returnable on 10th of September 2025. Mr. J, who appears for revenue?
Revenue.
Mr. J. Hendrick appears on behalf of the respondent number 1.
Lordship.
Mr.
The forest.
Hotel appears on behalf of the respondent number 2, 3, 4. And Mr. R.R. Gogoi appears for the respondent number 5. Stop. The said councils duly accepts notice on behalf of the said respondents. Extra copies of the writ petition be served upon them during the course of the day. The grievance of the petitioner herein is the non-granting of the permission. Non-granting of the NOC by the respondent authorities in spite of fulfilling the conditions for grant of the NOC. The counsel appearing on behalf, the learned senior counsel appearing on behalf of the petitioner submitted that the permission was applied on 11/2/2023. But even after a passage of after a passage of 2 years, no permission has been granted. The learned senior counsel further submitted that the reason, the reason for not granting the permission is on grounds or reason for not granting the permission is not the reason for withholding the permission is not based upon any law for which the present petition has been filed. This court have also taken note of that the dispute involved in the instant proceedings is also connected with another writ petition filed by the petitioner. That is WPC number 1634/2025. The respondents are directed to bring on record their stand by filing the affidavits on or before the next date. List the instant writ petition with WPC number 1634/2025 on the date fixed herein above. Econat WPC number 1634 list the matter on a date to decision notice, yeah,
10/9.
along with 4548 of 2020.
Deep reply.
Item 3.
Why? Mr. Gogoi, people appear. They appear when you appear. Huh?
And the second issue is that the structure of the writ petition, Lordship, no.
What is it challenging?
And you look at the structure of the writ petition, Lordship, no cost title, no nothing, no pagination in my
Huh?
copy. Yes, the Lordship.
My goodness. Who is this lawyer?
Even there is no pagination in my writ petition, Lordship. Even there is no pagination in my writ petition.
So he has surrendered.
He has surrendered. We have taken instruction that DFI is forwarded to the Secretary, Lordship. We're considering it.
Then he submitted a representation.
He is submitted representative before
Have you
DFI.
considered that?
We have sent it to the Secretary. Secretary is a competent authority. He will consider it.
None appears on behalf of the petitioner on call. Mr. R. Gogoi, appearing on behalf of the Forest Department, submits that the representations were submitted by the petitioner on 1/8/2025 have been forwarded.
To the Secretary, Lordship.
My goodness, this is have been forwarded to the respondent number,
They have not made him a party.
the principal secretary, some principal chief conservator of forest.
No, the Secretary. He'll take the call.
Then wouldn't the principal secretary to the government of Assam Department of Environment and Forest will come in?
He has made him a party, but most probably there is Secretary will take the call, Your Lordship.
Not the principal,
Not the Principal Secretary.
has forwarded the said representation to the authority concerned, that is the secretary
To the Government of Assam.
to the government of Assam Department of Forest,
Environment.
Environment and Forest Dispute. List the matter for 4 weeks.
All right.
Oh. Mr. Lordship.
This is the matter on dated at DTO on 15th of September 2025. The council appearing on behalf of the Forest Department shall apprise as to whether the representation have been duly considered.
All right.
May it please the Lord. This is regarding Lordship non-returning of earnest money deposit.
What?
Earnest money deposit, Lordship, he is an unsuccessful Lordship bidder in the tender process, Lordship. The petitioners.
On granting of the release of the earnest money.
Lordship.
Why?
Because my lord, the petitioner society is a unsuccessful bidder, Lordship, and some other part, society has been given the settlement.
You
Lordship,
participated in which contract?
a tender process, Lordship, for a mean mohol, Lordship.
How do I know, Mr. Council,
Lordship.
what contract? Nothing has been mentioned. Your annexure 1 is your application and the annexure 2 is this. There has to be certain formulation on which you have to do it. Huh? You are not a young advocate out here. You don't know how many years of practice you have.
Lordship, 19, Lordship.
19 years. And 19 years you do it in this manner. How do you take care of it? What contract? Which contract? Nobody knows.
I have made a.
There has to be some
Yes,
formulation.
I have
huh?
made, Lordship.
The notice inviting tender has to be brought in, that you have participated. Nothing is there. Where is the fact that you have deposited? You have only submitted the representation on.
The paragraph 2, Lordship, I have made a statement.
Where
Lordship.
is your saying that we have submitted the
Lordship.
deposit?
Paragraph number 2, Lord.
So,
Lordship, I will find, Lordship.
okay, issue notice making it returnable on 1st of December 2025. Mr. Fishery Department,
He probably pay his stuck in traffic. Just inform me.
You will appear.
He will appear for 1 and 2. I will appear for
Mr.
3 and
P.
4.
Sharma appears on behalf of the respondent numbers 1 and 2. Mr. Jibugal appears on behalf of the respondent number 3 and 4. Full stop. Extra copies of the writ petition be served upon them during the within 3 days. By Monday good. Full stop. The case of the petitioner herein is that the petitioner participated in the tender process initiated by the notice inviting tender dated 28/1/2021. The petitioner, at the time of participation, deposited an amount of rupees 1,80,000 as earnest money deposit. Full stop. The petitioner, the petitioner was not successful. And as such, the petitioner was entitled to the refund of the earnest money deposit. However, the same having not been done, the petitioner submitted a representation on 10/6/2021. Full stop. The case of the petitioner is that even after submitting the representation, the earnest money deposit having not been returned, the petitioner therefore being aggrieved has approached this court. The counsel for the respondents shall apprise this court by shall bring on record their response by filing affidavits on or before the next day.
But the mayor pray for an observation that pendency shall not be barred to consider the evidence.
Absolutely no. The reason
Obliged.
is you submitted a representation on 2021 and you have approached this court in 2025.
Only 25 representation.
So, see your annexure 1, last dated,
10/6/2021.
then
10/6/25.
I don't have the calendar for the month of January or February. I would have put it on January, February.
Item 5. Obliged.
Wait, please. My lord, this petitioner against the impugn order, lordship will find annexure 4, page 37.
Where
By
is
which,
the impugn order?
page 37. my lord.
Page 37.
Yes, lordship.
In the proceeding held on. Yes.
My bid bill was, my lord, 2,99,999. But instead of that, my lord, the settlement has been given lowest bidder,
Huh?
lowest bidder, my lord. Respondent number 8 is the lowest bidder.
How do we know your bid, how much?
My lord, I have stated, my lord,
Huh?
total, my lord, the 5% participated, my lord. And out of which, my lord, my bid was 2,99,999. And
2 lakh,
his bid is, my lord, 1,30,000.
2 lakh 90,
My lord, 2,99,999.
999.
Yes, my lord.
1 rupee short of 3 lakh. And it has been given to a lower bidder.
Lord.
Why, madam?
Lordship, impugned order was issued on 37. So has come today is and not enclose any comparative statement also.
My lord, I have approached, my lord. They have stated that as per clause 13, my lord. They have choice to, my lord, respondent number 8, my lord. Where the clause 13 say, my
What
lord.
does this person do? What is the tender of? Tender for?
It's a ghat, my lord. Very ghat.
Settlement is for Assam Panchayat for the Iman from Iman to Iman. Forgetting that Iman are invited. So you are giving ghats
Yes, my
to
lord.
whoever you feel like. Huh, madam?
Lordship.
You are giving
And the-
these ghats to those persons whom you like. Is it
Yes,
something
my
like
lord.
this?
Completely pick and choose.
Why have you given it to a 1,34,000?
Because market
I
value,
initially thought that this must be done by the BTC, but this also happens in the state of Assam. I'm saying the other departments of Assam. BTC has such things to do.
Lordship, instructions needed. So,
We have instructions by the end of next week.
Lordship. Lordship.
Issue notice. Who has granted this?
this is my
Alachwal
Gaon Panchayat.
Gaon Panchayat. So the Gaon Panchayat, can you accept it? No.
Well,
Number
up to-
6.
Up to 5 lakh Gaon Panchayat.
Up-
Up to 5 lakh Gaon Panchayat.
After amendment,
Now, can you accept notice on behalf of respondent number 6?
respondent number 6.
No.
Lordship, it's precedent. So I am not accepting. I am only for 1, 2, 4, and 7.
But the secretary has so you can appear for secretary,
Lordship.
no? Issue notice making it returnable on 22nd of August 2025. Full stop. For the present, comma, this court is not issuing notice upon the respondent number 5 and 6, which shall be considered on the next date. Ms. N. Bora,
Lordship. Number.
the Standing Counsel of the PNRD Department, accepts notice on behalf of the respondent numbers 1 to 4 and 7. Extra copies be furnished during the course of the day. The case of the petitioner herein is that the petitioner participated pursuant to a notice, tender notice dated 5/6/2025 for settlement of the Mulbari Balashar Matragola Ghat for the year 2025-26, along with 4 other bidders. The bid value of the petitioner was rupees 2,99,999. However, the respondent number 7 had allowed have granted the settlement in favor of the respondent number 8. To 5, 6, and 8. Respondent number 8. Though the respondent number 8 had quoted only rupees 1,34,167. This court is of this court therefore directs the respondents upon whom notice have been issued, and more particularly the respondent number 7, to apprise to place instructions as to why the respondent number 8 have been granted the settlement at a lower bid than that of the petitioner by the impugn order dated 30/7/2025. Full stop. The interim order so sought for shall be considered on the next date. Get your instruction.
Item 6.
Yes, Mr. Hawk.
My lord, here.
Bulky petition, what is this?
My lord, the petitioner, my lord, had participated in the tender, my lord.
Is it with
Subsequently-
PWD?
Yes, my lord.
Okay.
Subsequently, my lord, his tender was rejected in the technical evaluation, my lord, citing a new ground, my lord.
New ground,
Yes, my lord.
where is
On
it?
that, my lord, on eligibility criteria, my lord, the contractor must have, my lord, the experience of CTBS, my lord.
Huh?
Cement treated base, top base, my lord. That is not
Technical
included in the
qualification
bid document.
certificate? No. Why?
Because that was not in that, my lord, bid document, my lord. That was not an eligibility criteria, my lord. They have introduced this,
Show me where
my lord, can come to page 50, my
the
lord.
scope of the work includes a major item of CTSB and the bidder falls in similar work technical qualification. No, the scope of the work includes a major item of CTSB and the bidder has failed to demonstrate any similar works, including CSB. Considering the urgency of the work, all the bidders were requested to demonstrate execution of demand for a minimum of 40 CUM for technical qualification against criteria. Bidder failed to demonstrate and hence the bidder fails to satisfy the requirement of the criteria. Then,
My lord, this was never the part of the bid document, my lord. That CTBS, my lord,
No.
was not that part of the main.
they have mentioned about some clause, na,
Yes, my lord.
4.5.
My lord,
where
can
is
you come
that?
to page 50, my lord. Page 50, my lord, your lordship will find, my lord, the. qualification information.
4.5 AB. Satisfactory completed not less than 90% of the, as a prime contractor, at least one similar work of a value not less than 1/3 and of the DNIT. Document of one authenticate singular work should be furnished, cost of completed work of so and so. So you say that the CTSB
Yes, my lord, that was
is
never.
not there.
No, my lord.
My lord, so far as this particular work is concerned, if it is part of that particular work, a particular stage which is to be done, it will be there in the bid of quantities. Every phase of the work is there in the bid of quantities where they will have to quote their rate.
Where is the bill of quantities?
Bid of
No.
quantity is not a part of this, my lord. Documents, they have not placed it, my lord. Before it is announced.
It's a part of the bid of quantities.
Yes, it will be there, my lord, in the bid of quantities, this particular.
Because what I am submitting, my lord, that requirement of the CTBS, my lord, that was introduced during the bid technical evaluation, my lord.
No. You submit your bid of quantities.
Yes, my lord.
In your bid of quantities, you have to mention which are the components on which you are
Yes,
going
yes,
to
exactly.
give this amount.
Yes, my lord.
You have given a particular figure
Yes.
on the basis there. So that will include whether those terms are, but this is a case of experience.
Yes, my
No,
lord.
no,
That is CTBS, my
experience
lord.
means, my lord, when we have, that bill of quantity will be part of the, my lord, tender document. The rates will be quoted by the petitioner, but that format will be there. The items will be already mentioned, my lord, in the
But
bill of
how do you
quantity.
say so? Because this is a case of, to qualify for the award, each bidder in its name should have at least 5 years.
My lord.
That is so and so. Achieve minimum annual financial turnover of so and so. Satisfactorily completed not less than 90% of the work contract value as a prime contract, at least one similar work of value not less than Iman. Now, where is it mention of similar work anywhere?
My lord, 50, my lord.
Huh?
Page, my lord, kindly come to page 50, my lord.
50.
What is the experience they needed, my lord? Main item, my lord.
50,
Page
yes.
50, my lord. Qualification information, my lord.
We are concerned with JV, joint venture.
No, my
Oh,
lord.
no.
It is
Oh,
new.
okay.
Kindly come to, my lord, last question, my lord. Qualification information, my lord. Here, my lord, quantities of work executed as prime contractor of all the main items of the work described in the list documents in the 5 years. Kindly come to quantity of works performed, my lord. Here, my lord, nowhere mentioned, my lord, CTPS, my lord. And if your lordship, my lord, come to page, my lord, 137, my lord.
Yeah.
Here, my lord.
Submission of, okay, they have asked something.
Yes, my lord.
Of certified quantity of cement treated sub-base work executed. With reference, this is to inform you that during the course of technical evaluation of the above-mentioned package, it has been observed that one of the essential qualifying criteria pertains to execution of special item, namely cement treated sub-base as a single similar work. This was done when?
My lord, this letter was issued, my lord, during the technical evaluation, my lord.
All the participants are directed to submit details of the CSTB work executed by them to the tune of so and so, approximately. So this is like a corrigendum.
Yes, my lord. Here, my.
My lord, that opportunity was given to all, my lord, it is mentioned. in
No,
page
you,
141.
why didn't you mention about this thing earlier?
Yes, it should be the part of the.
Now this is a corrigendum.
Like,
Not
my
a
lord.
corrigendum,
It's a-
but
it's
an
a
opportunity
corrigendum.
was- Yes, clarification was sought for that whether you have experience in this particular part also.
No,
It was given to all the witnesses.
no, earlier there was no mention anything. Now this appears to be like a corrigendum.
Otherwise, yes.
Yes.
I
Now, if
can't
it
say
is a
about-
corrigendum means you are further narrowing
The scope.
the requirement.
That, my lord, without instruction, I can't say, but my lord, in the minutes, my lord, very candidly, they have mentioned in page 141 or
No,
so.
this is, it is
No, it is-
mentioned because of this.
Yes, yes, opportunity was given to all. Two failed, the two bidders failed. One is Anil Das Construction and the present petitioner. And my lord, this, not that my lord is limited to the petitioner, it was given to all.
Where?
Lord, you will see page 41, it is mentioned.
How many people were,
My lord, three bidders.
where is page
Three bidders.
51 it was mentioned?
Page 141, Lord, you will see at the
Ah.
top, Anupam Nirman, Anil Das Construction and Jiaur Pasa is the repetition. The Lord, you will see no. Scope of work includes a major item of CTSB.
No,
the bidder.
these are the bidders.
Yes, my lord.
But the earlier bidders were, means there were many other bidders
No,
could
no,
have
only three
participated.
bids. Three bids were appears, my lord. Three bids have been submitted for this particular tender. This is a technical evaluation sheet, my lord. Only three bids. Lord, you will see page 139. Out of three, my lord, the petitioner's technical bid has been rejected. Technical evaluation summary sheet.
So was this after the technical evaluation started? When was the technical bid opened?
It will be, my lord. No, the declaration is of 31/7/25.
No, when was the technical bid opened?
Lordship, I am giving the date.
It will be there in the tender document, na? Yes. Now kindly see page 21.
Well,
It is on 13/6/2025.
well,
So meaning thereby, seeking clarification, everything was done. On 13/6/2025, you opened,
Lordship.
then you saw that these are the two persons which we like and remove the other one.
Yes, exactly.
Something appears like that.
Well, that I will place the record, my lord. Why
Okay,
that?
I think we should state this. This is not a case by
But
which
my lord, the
what you
opportunity was
have
given to
done.
all.
It seems that you are further narrowing it down.
No, Lordship will
shouldn't
see,
have
my lord,
narrowed
no,
it
one
down.
thing, my lord.
Why you are narrowing it down after opening and at the time, more particularly, the
No, no,
moment
Lordship will see, my lord.
this particular letter also clearly shows
Yes.
that you have, there was no mention in earlier. Now you are just therefore putting another condition of CSTB.
No, Lordship will see, my lord, just for a moment, may I read page 141? I will place the record.
137, it
Let
clearly
me
stated.
make my
Yes,
submission.
yes.
Page 141 says the scope of work includes. So it is the scope of work which includes this item.
No,
And we
because
wanted it-
this. Earlier it was never there. So you by 137, you bring in this scope of work.
One.
Tomorrow you may say that, okay, there are 4 tenderers. We want to give it only to those people.
That is the
After
apprehension,
doing all
not
these
the
things.
proof, my lord.
Exactly.
That is the apprehension, my lord, not
That-
the.
No, no, that is
That is
exactly
the
happening.
apprehension that appears on the face of
No, no,
it.
if it is required, my lord, in that case, of course, my lord, we will definitely ask for
You
that.
should have gone for the year, but you are now, after opening the technical bid on 13/6/2025, you find out, no, now we want to add another condition by which we remove the other one and keep these two only.
Then I will, my lord, satisfy your
Well,
lord. Let me have the instruction.
Issue notice making it returnable on when
Short date, my lord. Otherwise also, my lord, if we'll have to be
notice returnable on 27th August or
Well-
22nd August.
22nd, my lord. I can come up with the instruction,
On 22nd of August 2025.
my lord.
Mr. B. Gogoi accepts notice on behalf of the respondent numbers 1,
All-
2,
all,
and 3. The petitioner herein and extra copies be served during the course of the day.
Right.
The petitioner herein is aggrieved by the action on the part of the respondents in disqualifying disqualifying the petitioner in the technical bid. It is the specific case of the petitioner that pursuant to a notice inviting tender issued for construction of road and bridge project under SOPD-G for the years 2024-25 in Buxa district. The petitioner, along with various other bidders, participated in the said bid. It is the further case of the petitioner that as per the tender time schedule, so mentioned in the bid document, the opening of the technical bid was on the last date for submission of the bid was on 13/6/2025. And the opening of the technical bid was on the same date. Referring to clause 4.5A, capital A, of the bid document of the, what is this document?
Actually, it is bid document for a IT
Of
payment,
the,
information to bidder.
of the instructions to the bidder. The learned counsel appearing on behalf of the petitioner submits that the reason for which the petitioner's technical bid was rejected does not find place in the original bid document and also in clause 4.5 capital A, small b, capital A. The learned counsel further drew the attention of this court to the qualifications, informations, and the qualification information, which is section 2, and submitted that the requirement of cement treated subbase as a qualification criteria was not there. However, after opening of the bid, the respondents, in order to disqualify the petitioner, have adopted another criteria, that is requirement of submission of certified quantity of cement treated subbase, because CTSB work. And as such, and on the basis thereof, have rejected the bid of the petitioner. It is the further contention of the petitioner that the changing of the goalpost after looking into the technical bid in order to favor some contractors is not in accordance with Article 14 of the Constitution. Upon hearing the learned counsels appearing on behalf of the petitioner, now, Mr. B. Gogoi, the learned counsel appearing on behalf of the respondents, submitted that the petitioner herein was given an opportunity to provide details, to submit details of the CTSB work via the communication dated 26/6/2025. And as such, the petitioner cannot have a grievance that the respondents have not given the petitioner an opportunity to execute, to provide the necessary details. He, however, submits that he would have to require instructions, he has to obtain instruction as to why the CTSB work is an essential part of the contract. And without it, the contract, and without there being experienced contractors executing CTSB work, granting of the contract would not be in the interest of the respondent authorities. Taking into account the said aspect, this court grants an opportunity to the respondents to place before this court the instructions as to why the new tender condition and the new qualifying condition of CTSB was introduced, why the clarification was sought for as regards experience in CTSB work by the communication dated 26/6/2025, and as to whether without the CTSB work, without having the qualification of the CTSB work, the respondents, the granting of the contract without the can the contract be granted to the contractors or not? The court shall consider what is the status of the contract?
I no knowledge, madam. But my lord, only on 31st of July.
Therefore, we are 13
by
days
now-
there.
Probably if lordship will say no final order should be issued, man, at least if it is open.
It is observed that next date, no final orders be passed in the said contract.
No.
I'm deeply obliged, madam.
On 22nd, man. 26.
Item 7.
At 2 p.m.
Yes, sir.
We finish it off.
Right.
Mr. Hawk, you have one problem. The opportunity has been granted to you. I make it clear. Secondly, the problem is there are other two bidders who have been held to be qualified.
Yes, madam.
Now with FCONS being there, more particularly paragraph number 22, wherein it mandates that a constitutional court should insist all the eligible bidders to be made parties. These are problems which you are going to face on the next stage. So I'm putting you to notice. Be careful.
May I please, your lordship?
2 PM day. Yes.
Herein, your lordship, the petitioner
NIT, what is
NIT
the
there-
NIT for?
to NIT, your lordship, in respect of the past NIT, the petitioner submitted his application.
Ah.
The petitioner, along with some others, had submitted their application. And the bids in respect of the past NIT were opened on the scheduled date. And the NIT, the tender application of the petitioner was found valid,
Found?
was found valid.
Ah.
But no such settlement has been issued, and thereafter the subsequent NIT has been issued.
I'm having the similar matter. When am I having this?
18, your lordship.
Yes, my lord, but I have some instruction to do, my lord. Because of
His,
that.
his case is that why you should not invoke 1055. As per 1051, the tender should be settled
Better.
by you.
Yes.
That is your case.
This is the many.
Members of the it is found that there was only one responsive date submitted in each of the three. Other than no response. Wait, what is this?
This is,
Public procurement act?
yes,
Who is this? Your name is what? Mukut Medi.
yes.
Okay, formal.
My minutes of the meeting.
Abdul Kataria. Bakira, no. Abdul Mutibur Rahman, no. So in your case, there is only one person who is the eligible bidder.
That is the petitioner, your lordship.
So they don't want to give it to you.
Yes.
And he participated in the second.
They insist
tender
that
also.
there should be a fresh tender.
And he participated in the second also, my son.
You participate in
Yes,
this?
already. I have instructed.
Because initially, your lordship,
And
issuance
then
was
you
there,
have
your
made
lordship.
this court. Have you mentioned in your petition?
Yes, I have mentioned, your lordship.
Show me. Where is it? We are concerned with Sutarpara Pasughat.
Yes.
Yes. And the procurement rule is saying, my lord, if only one valid tender, my lord, to attract more tenderers, my lord, we can issue re-tender, my lord.
Where have you mentioned that you have participated? Ah, there, paragraph 17.
17, yes.
What
Yes.
type of counsel you are? For me to find out is much easier.
I'm sorry. But since insurance,
Yes,
there
my
was your,
Impugn re-NIT dated 25/7/2000, the petitioner has also submitted his application because at last, the respondent number 3 had denied to consider the claim of the petitioner, and being helpless, he had submitted again his tender application to get the settlement. But till now, no such process of settlement have been proceeded as per the NIT dated. Hence, it is highly required to pass an interim order of staying the further process of settlement only in respect of demand in terms of the re-NIT, otherwise the petitioner would be prejudiced.
but the fact,
Yes, now let us see whether you have a case as per the procurement rules where
My lord, sub rule 20, my lord.
where a situation arises where all the evaluation of bid, the bid evaluation ends up with only one bid. The committee shall check as to whether while putting the demand on the necessary correct competition like demand and if not, the committee shall recommend cancellation of any separate bid or adherence to the. Now, you see here, where is the committee's decision? The committee rejected here. The meeting of the technical member, the meeting was convened to evaluate the technical bid of 10 bazaars and so on. Marketing is further out of demand withdrawn. Induction.
Last three paragraphs, well.
Injunction passed by demand. In respect of and the received. Rejected number 10 on submission of the bill of with other relevant. But Mr. Dutta, if we go by 21, read it.
These rules. Subject to provisions of the Act, these rules, the state government in the finance department may, by notification, prescribe further steps to measures to be adopted in the process of invitation, submission, opening and evaluation of bids for any of all the methods of procurement. The state procurement facilities sale may recommend it to the state government benchmarking standards or key performance indices for procurement processes.
Are you reading 21?
My lord, 21 or 21, my lord.
The number one on top.
Number one, yes, my lord. When a situation arises where after the evaluation of bids, the bid evaluation committee ends up with one respective bid only, the committee shall check as to whether while floating the notice inviting bids, all necessary requirements to encourage competition like standard bidding terms and conditions, industry-friendly specifications, wide publicity, sufficient time for formulation of bids, etc. are fulfilled. If not, the committee shall recommend cancellation of the bid process and issue of fresh invitation for bids after rectifying the deficiencies, and the procurement entity shall act accordingly as recommended.
Now see your instructions.
Instruction is saying, my lord, that only one bidder,
So we
my
are
lord,
doing.
for
And
attract
can you do that? Can
Well,
you apply on that? You can't.
directly, not my lord, but
Indirectly also you can.
my lord, one more thing is aspect is there, my lord, if respectfully submit, my lord. The whole writ petition, my lord, there is nothing allegation of malafide or something like that. And this is established law, my lord, that without the allegation of malafide, in a tender process, the judicial review or the jurisdiction of the writ petition shall not be applied, my lord. That is one of my submission, my lord. Because in the whole writ
I will
petition,
take it that Mr. Khan has made a submission that it's a malice in law in applying a provision which does not apply. The
but
facts.
in the petition, it's not a single line.
It is all improvisation of.
But
the submission.
arbitrary, your lordship, I have mentioned it, your lordship. And from the condition, your lordship, the condition number 11 talks about reissuing NIT, your lordship. If the bid amount is not found suitable, then only, and otherwise there is no any clause, your lordship.
So the reason on which it has gone, you should interpret.
And 1055 is also saying, my lord, in the Assam and Panchayat Act, the failure to settle any hut for want of adequate value. The concerned Gaon Panchayat, Anchalik Panchayat and Zilla Parishad, as may be decided by the next higher body, may be entrusted with the direct management of such hut by the Gaon Panchayat, Anchalik Panchayat and Zilla Parishad. They can directly also manage, but in this case, my lord, to attract more, my lord, bidders to generate revenue, we are my lord, retendering, and he participated, duly participated, my lord.
There were three tenderers who had submitted.
My lord, but the two tenderers are not responsible, my lord.
Why you are insisting on the Bakijai notice? Bakijai's notice, why you, on one hand, now you have to do so. You should have taken that other ground. You're taking a wrong ground out there.
Lordship may issue short notice, maybe in the second tender also, because, my lord, we
Now
have
you-
not,
Now you are going to make another minutes after.
no, my lord, no,
reason.
my lord. Because financial bids were not open, my lord. In the first also,
Necessary.
not open, because only technical bids were open. Thereafter, it was the minus of that was.
You will be at liberty to take a call on that.
Lordship may
But that
issue
isn't the
short notice,
reason
my
why
lord.
you have
We will
done
not finalize, my lord. Lordship may issue short notice. I'll place
Huh?
specific instruction, my lord, thereafter. After
Instruction, what better can be?
this is the minus, my lord.
This is the instruction.
This is the minus of the first tender, my lord, after the first tender. And if
We are not concerned with the second one. We are only concerned with the first one.
my lord, lordship may grant some time, I'll discuss with my client, my lord, so that I can give a
So you want
solution.
I should stay the
Just one day, my lord. Tomorrow maybe fix, my lord. Tomorrow, my lord. Because this technical bid not opened yet. We will not finalize, that may be observed, my lord. You know, in the similar matter also, lordship will observe, my lord. We can go it,
No, no,
but
no.
not
no.
open.
There, what case he had, that was not a case where going for retender. This is a case where you have gone for a retender.
In
But
that
for
case also, we
reasons
have
otherwise,
retendered, my lord.
Which is not bona fide.
My lord, this minus, my lord, is saying in that case, my lord, that market is also in the retender list.
Which one?
That market, there another case, my lord. In the minus, my lord, lordship may kindly see.
So those two other
Sir.
petitions which I fixed it on 18th.
Yes. The second last paragraph, my lord.
Hello. Issue notice. You want a notice? Issue notice making it returnable on 18th,
My lord.
18/8/2025. Mr. S. Doctor accepts notice on behalf of the respondent number 1 to 4. Extra copy of the petition is served upon him during the course of the day.
1 to 4.
The case of the petitioner herein is that pursuant to a notice inviting tender dated 5/6/2025, the petitioner participated in the said tender process in respect to Uttarpara Pasughat for the period 1/8/2025 to 30/6/2026. Full stop. As per the petitioner, there were three bidders who had participated, and the petitioner was the eligible bidder. However, without assigning any reasons, the said bid was cancelled. The respondents have issued another tender notice on 25/7/2025, wherein the said Sutarpara Pasugat, the settlement of Sutarpara Pasugat was also included in the new tender process. The petitioner, though, had participated in the subsequent tender dated 25/7/2025, but the same have been done as the respondents were not considering the case of the petitioner, were done under compulsion as the respondents were not considering the case of the petitioner. The case of the petitioner, therefore, in the instant proceedings is that for no rhyme or reason, the respondent authorities have cancelled the settlement in respect of Sutarpara Pasugat in favor of the petitioner and have proceeded with a fresh tender. Mr. S. Tutu, appearing on behalf of the petition respondents, have placed before this court are minutes of the tender evaluation committee held on 24/7/2025, which led to the issuance of the fresh NIT dated 25/7/2025. The said minutes, along with the documents enclosed, are collectively kept on record and marked with the letter X. From a perusal of the said document, it revealed that as there was only one bidder in respect to the Sutarpara Pasuga, the respondent authority have thought it proper to go for a fresh tender. Mr. S. Dutta had relied upon rule of
My lord,
is that a rule or act?
rule, my lord.
Rule 20, small Roman 1.
My lord, 23 sub rule 20.
Huh?
Rule 23 sub rule 20.
Rule 23, 20, Roman 1
Yes.
of the Assam Procurement Rules 2022.
20.
20, rules 20.
Assam Public
support-
Procurement Rules.
To support the case of the respondents and the decisions so taken in the tender evaluation committee dated 24/7/2025. However, this court have duly perused the rule 23 (20) small 1, and it is seen that it is only when the tender evaluation committee, upon finding that there was only a single bidder and there were no other bidder and there was no proper notices being issued, such exercise can be carried out. However, a perusal of the minutes of the tender evaluation committee, which is kept on record and marked with the letter X, and the documents enclosed therewith, shows that in the case of the Sutarpara Pasugat, there are 3 bidders who had participated. It is a different thing that the other 2 bidders were not technically qualified. In the privacy opinion of this court, the reasons so given in the minutes of the tender evaluation committee is not in consonance with the settled principles of law, and more particularly rule 23 (20) Roman 1 of the Assam Procurement Rules 2020. Considering the above, this court therefore finds that the petitioner have been able to make out a strong case for stay of the settlement in respect to the fresh tender notice inviting tender dated 25/7/2025 in the case of Sutarpar Pasugat settlement. Accordingly, this court directs the respondent authorities to proceed with the tender. Directs the respondent authority that while proceeding with the fresh tender dated 25/7/2025 shall not make any settlement on the basis of the said tender in respect to Sutarpara Pasugat till the next month.
All right.
Hello.
Item 8.
Lordship, please.
What is this?
This is my lord challenging our terms and conditions of an NIT, which has been introduced on 25th of July, 2020.
This is an NIT season, so many NIT.
I'm sorry, my lord.
Yes, tell me, what
Yes.
are you challenging?
Yes, ma'am. Madam, there are 2 aspects of this, madam. The first aspect is that the terms and conditions which have been introduced now are completely arbitrary, discriminatory. They are also restricting a lot of tenderers who had already participated in one of the tenders which was initially floated. So in a kind, this is actually a retendering because the initial tender had 24 winches. These are scrapping winches of wells, my lord, where 12 has already been awarded. The remaining 12 is what is in dispute and the bone of contention.
So the 12 in regards to the previous NIT has already been allotted and they are running. Now, these are a separate terms and conditions which have been imposed for the remaining 12. And I'll tell your lordships, why has that happened? Now, these conditions that have been imposed, my lord, the petitioner who was actually qualified under the previous NIT now cannot participate or even qualify under the NIT. The second leg, my lord, is the NIT that was introduced on 6th of June 2024, in which the petitioner along with some other bidders had already qualified, my lord. The 12 has now been demarcated. So the previous NIT, which is 24, 12 stands allotted. 12 is what they had to retender. But by bringing in a stringent clause, there are now two set of conditions. One set under the same umbrella is in terms of conditions under the 6th NIT. Now they will be appointed under a subsequent NIT with a different set of norms. So my case is, my lord, that should not have been done. I have already qualified. Had those 10, which was qualified initially by one tenderer, because the tendering condition was either you can apply for one or you can multiple. In terms of that, my lord, the person who qualified the company, his NIT was, his NOA was terminated by Oil India because there were certain allegations of fraud and forgery, which was ultimately found out, and it was terminated. Subsequent to that, my lord, there was a provisions in the NIT where it says that if the first 10 goes, we go into a clause which is called the price variation clause, in terms of which the other tenderers remaining could have been distributed. Now that was not done, and subsequently this retendering has been done with certain conditions which completely bars me along with other bidders also who's not been able to participate. Because in this condition, my lord, is that you have to participate for the entire 12. I cannot participate in one or multiple. So that is a right which has been taken away, for which I have not been able to participate.
So now they want the person who will be participating.
Yes, madam.
Will have to participate
And bid for 12.
Have to vote for all 12.
All the 12 together. The previous NIT had one or multiple. So that was even
Now
in
they are
2020.
limiting the competition.
Yes, and also, my lord, because if
You have only one.
I have bidded for one in the previous one. Now I can't obviously bid also because my financials are such that I cannot participate in the 12th. I bidded for one. I would have qualified if the NIT would have continued in terms of the redistribution that had happened, had the retendering did not have happened. But in this case, Oil India had decided to go for the retendering.
No, there was once an NIT issued on
6/6/2024.
That is
Yes,
how
ma'am.
many?
Yes, madam. That was for 24.
Where is it?
Yes, madam. I just take you to the lordships to the NIT, madam. That's at page 85, madam.
Where is it?
Yes, madam. Madam, 127, madam. 3.
Yes.
Yes, madam. I'm reading 3. Bidders to confirm acceptance of the following, madam. ONGC reserves the right to split total quantity of scrapping winches among the acceptable bidders of a respective assets who confirm to the match their rates to the lowest acceptable bidder. The total number of scrapping units to be hired in Assam asset is 24 and Ahmedabad is 14. So out of 24, minor 12 has already been given. There is no dispute on that 12. It is only the 12 remaining which is under dispute. Now, my lord,
12.
Yes, madam.
And in that earlier one, you got one.
Yeah, I did not get it because they scrapped it. Ultimately, they retendered it now. In spite of the fact there was a provision.
How did they? Because you are saying 12 has already over.
Yes, has already been given. The remaining 12.
So, in terms with the earlier tender,
Yes, ma'am.
6/6/2024.
Yes,
Out of 24, 12 has been given.
Given.
Why you didn't get it?
Because, my lord, they have that 12 in terms of which was allotted to the previous bidder who qualified, who was L1. He was terminated after giving the contract.
So there
So the
remain
team-
another 12.
Another 12.
So actually 24 was allotted, was awarded.
It was awarded.
Was awarded. However, the lowest bidder who was granted issued 12.
Yes.
That contract was terminated.
Terminated.
For which this 12 has come.
This 12 now has been retendered.
Now you say now they are asking for a condition by which they want a person to quote for the entire 12. And you having one, you are out.
Yes, I am out. Also because of the fact that the financials, my lord, In the previous NIT, it's a pro rata calculation, 24 winches that was introduced, my lord. The amount that was required was around 6 crores. So even if we go on a pro rata base, my lord, which is around 25 lakhs per winches, because this winches will also have a truck, the winches and all the human resources that are inclined and attached to it, it comes to around 25 lakhs. Now, presuming, my lord, that if that's the rate to be calculated even in this NIT, my lord, it goes to around 3 crores. So the turnover will be more than 3 crores. I, being an MSME qualified, I will not have that kind of a qualification. Therefore, the one that was introduced, I could have got. And subsequently, my lord, even if those 10 could have been re-allotted to the people who had qualified under the NIT, could have been distributed. But that anyway, my lord, the respondents' authorities have said no, because could be a fact that the financials were all open. There could be situations, so they decided to do a retendering. I could have still had no problems coming to your lordships until and unless this restriction was imposed. So I'm saying that, my lord, when the 12 who have already been appointed in one set of norms, can the contract be now divided and appoint another 12 with a different set of norms, which is completely done so that people like me and the other bidders cannot participate? So that is my biggest grievance. Had it been one, I'd have qualified, maybe two. Even 20 was also one. 2020 NIT, which I've also relied on it, my lord. So the trend was that it is only now, maybe because of the steps that I took in that NIT, where I had certain grievances against a person who was appointed. I filed a complaint that was taken up to the IEM. Subsequently, there was a hearing and then the contract was terminated. Could be one of the reasons why. But the question is, I should not be penalized just because of that. I had a right, I could have qualified if these terms and conditions were not being imposed. So may I just take your lordships to the finances in this NIT, my lord, because in the same NIT, my lord, I qualified. My list is already available. If your lordships can come to page 206 and 209, this is where I qualified. But my problem is this restriction now.
The question is very simple. Earlier, there was a tender.
Yes, ma'am.
Having 24
Yes, ma'am.
rigs or whatever may be.
Yes, ma'am. Scrapping
24
wells.
winches,
Yes, winches.
out of which that tender was allotted to these 24 winches L1.
Right.
The L1 contract was terminated.
Right.
And
He did it for
therefore
10,
these
ma'am.
12
I'm
are
sorry.
now available,
Yes.
for which they have issued a fresh tender.
Retendering. Yes, my lord.
And this fresh tender contains a clause by which a person has to quote for all the 12.
12. Instead of one.
Now, the question is, should this court exercise the
Yes,
power of judicial review?
I understand.
Well,
May I'll just try to satisfy your lordships on that ground. Would your lordships be kind enough to come to the new NIT, my lord, which has been introduced?
No, the fact is, I don't need to look into it. I accept whatever you were saying. But why
Can be,
this
my lord.
court
This
interfere?
has
This
the
is the-
power.
this is the- They want 12%. We have initiated given like this. Earlier, we have tasted very bad luck. Now we are not doing.
Could it be a situation, my lord, that two under the same contract, 12 people are appointed in terms of one set of norms, and the other 12 just
It is not other 12. That is why I'm saying. It is not the other 12. Now these came in. Because there was a termination, now these 12 again came up for tendering.
correct?
Now these authority think that we want those persons who are 12. And therefore these particular 12, a person has to quote and we'll give it to them. We don't want the many people. We don't want to deal with 10%. We'll deal only with 1%. That's the authority's wisdom. Why does this court tell me any law to the effect that this court should, in such circumstances, think about the MSEB, think about the other persons who may not be in a position, that there are judgments to the effect that if you are limiting the competition in this manner, the public interest would be more hard.
I just 2 minutes, my lord. Any contract, when it is initially issued with the intent that it needs to be fair, transparent, and most amount of the competitiveness that arises. The entire effort in this was to encourage certain kind of bidders who could have also participated and
Earlier.
performed earlier.
So they
So
have
the intent.
I'm telling you, they therefore say that look here, we don't.
So, but
want
there is
to
no
see-
deliberation, my lord,
We
to say,
will have only one, and we'll give it to him only.
my lord, there is no deliberation to say, why was this introduced? There is nothing to say, my lord, that these
The
conditions would.
deliberation will be there in the records.
that would have to substantiate with the terms and conditions.
So you-
Why was this required?
If you taking into account of the environmental degradation which sorts a fat petition, you may be entitled to just a notice.
No, my,
Only a notice, nothing
I-
more than that.
I'll just come to that, my lord. In today's time, my lord, giving 12 was always a prerogative. The entire 12 was a prerogative of the respondent authorities. In that process, my lord, the same 12 was allotted and distributed in a manner where everybody could have participated. Today, if ultimately the entire effort is to make sure that the 12 winches that has to be supported, which has to be performed, it is not necessary that only one person can perform. You are completely restricting the other people who would have otherwise qualified, my lord. I could have understood if I had have not qualified in the last level at all.
They don't want,
No, but my lord, for
why
that,
should this court interfere with their wisdom? Give me a good reason.
but these are
The
only
reasons are
tailor-made.
not- The reasons which you are saying are not good.
No, but my lord, that
So
these
be
are,
that it is the requirement of law. They have some
I will,
members, they
I will.
have some regulations to the effect wherein it maintains that you have to maintain all these things, that you are to provide distributive justice or distributive, there should be a fair distribution amongst all. Show me.
yes, I will, my lord. I will show that. I will show that.
Well,
I will just show it, my lord.
now.
Yes, my lord. Yes,
Rest I know what is it. Show me now.
yes. I'm sure my lord has already seen this judgment many times, which has been referred. My lord will come to para 23, my lord.
Yeah.
Not the tenderer who qualified initially, there were 10 plus 2, but the 2 still remains. They could not be allotted because 3 people who were qualifying on that list, my lord, they had similarly bidded, but there was no provision in the NIT to accommodate such situations. Therefore, those 2 was never allotted. So it was only 10. 2 still remained under the old NIT. They could not allot the 2. Because in terms of that, they could not give me an NOA because the prices were all similar. And there was no provision under the contract to say in similarly situated situations like this, what do you do? So that 2 was never allotted. That 2 contract, that 2 remained. Only 10 was allotted to so-and-so who participated. So that 2 contracts, the 2 which were still remaining subsequently. My lord, may just come to page 20, para 23 of the judgment, my lord. The matter, I'm reading paragraph number C, my lord. The matter of formulating conditions of a tender document and awarding a tender, greater latitude is required to be considered to the state authorities unless action of the tendering authority is found to be malicious and the misuse of his statutory power, interference of the court is not warranted. Certain precondition and qualifications, I'm reading beyond my lord, for the tenderers have to be laid down to ensure that the contractor has the capacity and the resources to successfully execute the work. So my condition was that, my lord, in terms of the previous NIT, I could successfully complete the contract. In this, my lord, the moment you bring in a bar for me to even participate, that is the restriction that has been imposed. That restriction, my lord, can it be imposed just to put me out of the race when I could have qualified under this?
Very poor case. If
No,
you're
but my
making that submission, this is a case for immediate dismissal,
No, my lord.
not even a notice.
No, my lord. But the question still remains: is should I been penalized for that?
Yes, Mr. Pukon.
Even if the authorities decide, my lord, tomorrow to say that no, I will want to give 12 to everybody, 10 to everybody, and not to the rest. I could have still been given an opportunity, my lord, to have participated in the tender. In this, I had even stand a chance.
Now,
My
what do
lord.
you want, a notice or a dismissal? Which one? Either of it. State who is not a question. Notice or a dismissal? Any of what are you going to take?
Because it's 18th is the last day, my lord. My lord may say at least a notice, and then if everything should, maybe if it is awarded, nothing should be awarded without the condition. mission of your court.
No, no.
Otherwise, everything will.
No, no, no.
But of the entire process,
I
I will
may
not be able
say
to
only
participate.
one thing, case saving you may get, that any tender issue shall be subject to the outcome of the writ petition. I hope, Mr. Bolwa, you have no objection.
Yeah, no objection.
My lord, I am appearing
Oh,
for
yes.
the ONGC. I'm sorry, my lord, I could
Oh,
not
we
be
have not
personally
seen the
present.
Advocate General. Where is he? Yes.
My
Tell
lord,
me.
I'm still stuck in Itanagar. I am
Ah.
appearing for ONGC in this matter.
Tell
As your
him,
lordship has
Honorable
rightly
High
said,
Court there.
as
Yes, tell
your
me,
lord,
what do you have to say?
as your lordship has rightly said, perhaps this is a case for dismissal in limine. The law is very subtle. This is a matter of
But,
policy.
Mr. Aichaudhry, tell me one thing. It may be fair, it may be reasonable for this court to dismiss the writ petition. But would it be reasonable for this court to dismiss, reasonable to the counsel for the petitioner to get a dismissal limine? I think
Well,
he should get a notice.
my lord, that I leave it to your lordship. That I leave it to your lordship.
He should get at least a notice. Otherwise also.
Well, that I'll absolutely leave it to your lordship.
But may I once again insist, my lord, that the first conditions, the first 12 who have been appointed in the terms and conditions of the previous NIT. These 12, which arises in continuation to the same NIT, will now be appointed with a separate set of norms. They will be doing the same job. They are all qualified to do the same job. In that NIT 1-1, people who have qualified, the 12 are all applied for 1-1. Would it be fair that I would not even get an opportunity to participate? The fact that I could have otherwise done the job which has been allotted to the next of the 12. That's all my case is. I am saying don't give me.
You will get a chance if they don't get the 12 people. If they don't get a bidder who can quote for 12, you'll get a chance.
There'll be no opportunity because this has been completely done.
You have the person, there are persons who can quote for 12.
They could be, my lord. I'm not saying that. All I'm saying is that the previous people who have been appointed and are performing in a similar way that I have been participated. I would have been similarly situated like that. And I could have perhaps done the same job had this condition not been imposed. Let them say that it's fair enough for them. Why 12? Why 10? Just because of the step? This was all 10 with 1 and multiple. They could have gone ahead with that.
Mukund, that is why I am considering issuance of a notice soon.
I'm grateful, man.
For that,
that's all I'm saying, man. They could not have.
No,
doesn't arise. This is a different set of norms for one person, different set of norms for the other person. That's all I'm trying to say, my lord. That is my only request. Can it be done?
I give a particular time for a petition to be argued. Now, the moment it is beyond the notice, I go for disposal. What do you want?
I leave it to your lordship. Your lordship best.
Issue notice. Issue notice. There are so many people. All these people have participated.
Yes, my lord. Those are 5.
Why do you need the performer respondent?
My lord.
Why? What is the performer respondent business?
Very interesting,
in fact, on the first round, he was
the one who was terminated.
So he has nothing to do.
There's no subsequent orders being passed after termination. So he's very well now alive to participate in this in spite of.
No. That is the incorrect submission, my lord. Because we have initiated a process of blacklisting him.
Yes, that is. I mean, I'm not aware of it, but this is the situation. Therefore, I
don't require 17 then. You want to do
since right now I don't have any documents to substantiate that. All I can
notice making it returnable on 15th of September 2025. Steps be taken. Mr. P. Bolwa accepts notice on behalf of the respondent numbers 1, 2, 3, 4. Extra copies be furnished to him by Monday. As regards the respondent numbers 5 to 17, the petitioner is directed to take steps by way of registered as well as usual. Liberty further is given to the petitioner to take steps by way of dusty. routed through the registry of this court insofar as the respondent numbers 5 to 17 to the registry of this court and file an affidavit of service on or before the next date. The petitioner herein has approached this court challenging the notice inviting bid, notice, the tender, the notice inviting tender bearing number GEM oblique 2025 oblique B oblique 6491739 dated 25/7/2025. On the ground that the eligibility conditions which have been imposed were such whereby the petitioner who could have otherwise participated have been debarred from participating. The facts as submitted by the learned counsel for the petitioner, Mr. R.B. Pukar, is that that the respondent number one, no? The respondent number one had issued a notice inviting tender on 6/6/2024 for hiring or scrapping winches. Winches, no?
Winches, yes.
Yes. WINCHES.
Yes.
Winches. For Assam. And 14 scrapping winches for Ahmedabad for a period of 5 years. In pursuance to in the said notice inviting tender, the petitioner participated. The petitioner could participate in view of the eligibility conditions mentioned, which permitted an eligible bidder to quote for one winch also. One winch, no?
One
scrapping winch.
Yes.
The petitioner, however, did not get any, the petitioner, however, was not awarded any contract in pursuance to the said notice inviting tender dated 6/6/2024 in respect to the 24 scrapping winches for the state of Assam. For Assam. The learned counsel appearing on behalf of the petitioner, drawing the attention to the pleadings as well as the documents on record further submitted, that there was a bidder who is the respondent number 17, who was awarded 12 scrapping winches.
10.
10 scrapping winches. Now they have gone for 12.
Now they have gone for 12 because 2 were left, as I said, my lord, that could not be given to anybody.
So
Because
therefore, it was only given for 22.
22.
Earlier it was
Given for 22. Correct.
Did not receive was not granted any allotment earlier in terms with the notice inviting tender dated 6/6/2020. The learned counsel submitted that out of the 24 scrapping winches for Assam, for the establishment of the respondent number 1 corporation in Assam, 22 scrapping winches were contracts in respect to 22 scrapping winches were awarded. it further appears from the submissions made by the learned counsel for the petitioner, as well as the documents on record, that the respondent number 70, performer respondent number 17, who was awarded 10 scrapping winches. The said award was the said award of the contractual award was terminated. Terminated, resulting in the necessity of issuance of a fresh tender for hiring of 12 scrapping winches. Bracketed there, 10 in view of the termination of the respondent performer respondent number 17's contract, and 2 on account of the leftover scrapping winches which could not be awarded in respect of contracts could not be awarded. It is further seen that pursuant thereto, the impugned notice inviting tender dated 25/7/2025 was issued for hiring of 12 scrapping winches. Which clause? We are don't like it. Which one?
The eligibility man.
Which
Yes,
one?
ma'am. Well, that page. $354, my lord.
Which one?
354.
Where
The
it
eligibility
says that
criteria.
it is required for 12
B1.
A.
Sorry, madam, 357. Sorry, 357. Number 4, C11.
Where?
Madam,
Where is
Number 4.
Number 4.
Yes, A. Bidders are
Bidders are required to quote prices.
for 12 scrapping units, including the GST.
The counsel appearing on behalf of the petitioner submitted that in terms with clause C4, C.4 of the, what is this document?
This is the bid document, madam. That starts at
That I
283,
know.
madam.
Of the
Bid
of the
evaluation
bid
criteria.
evaluation criteria, project experience and qualifying criteria, bracket annexure 4 to the bid document. The bidders are required to quote prices for all 12 scrapping units, inclusive of GST, only on GEM portal, along with financial breakup sought on the GEM portal. The learned counsel therefore submitted that as the petitioner has only one
Yes, ma'am.
scrapping unit, the petitioner have been debarred from participation in the said notice, in the said tender process initiated by the NIT dated 25/7/2025. Then counsel appearing on behalf of the petitioner submitted that when in respect to the same scrapping units, the tender conditions as stipulated in the notice inviting tender dated 6/6/2024 permitted the bidders to quote for one scrapping unit. The tendering authority in the present in the impugned tender have made it mandatory for the bidders to quote for 12 scrapping units, meaning thereby to lessen the competition. That too without any reasonable cause. The learned counsel submitted that if such actions on the part of the respondent authority are without reasonable cause to exclude competition, the actions of such authorities would be unfair and unjust, and accordingly would invite would amount to violation of Article 14 of the Constitution. He therefore submitted that the learned counsel therefore submitted that this is a fit case wherein this court is required to pass appropriate interim orders staying the further proceedings or staying the tender process till a tender process. Mr. I. Chaudhary, the learned senior counsel, assisted by Mr. P. Borua, appearing on behalf of the respondent numbers 1 to 4, submitted that the instant case in that as per the settled principles of law, the tendering authority is the best judge to decide what conditions are required to be incorporated. The learned counsel senior counsel submitted that in the instant case, the respondent authorities is of the opinion that there is a requirement of having tenderers quoting for the 12 scrapping units. And the same, under no circumstances, can be said to be unreasonable or unfair. The counsel for the petition respondents have referred to the judgment of the Supreme Court in the case of Michigan Rubber India Limited versus State of Karnataka, reported in 2012 8 SCC 216, and more particularly in paragraph number 12, whereby the Supreme Court have deduced the principles when the interference is called for in respect to the eligibility conditions set out in the tender. This court, having heard the learned counsels appearing on behalf of the parties, and also taking into account the judgment of the Supreme Court in the case of Michigan Rubber India Limited, wherein the Supreme Court had categorically observed that the fixation of the value of the tender is entirely within the purview of the executive, and the courts hardly have any role in this process except for striking down such action of the executive as is proved to be arbitrary or unreasonable. This court further is of the opinion that prima facie it does not appear for this court that the action on the part of the respondent authorities to seek bidders having the capacity of having 12 scrapping units to submit the tender is unfair or unreasonable. Be that as it may, this can only be ascertained when due affidavits are when the records are produced on the basis of which the said decision have been taken. Full stop. Accordingly, though this court is not inclined to pass any interim orders, but however observes that any decision taken in the notice in respect to the notice inviting tender dated 25/7/2025 shall be subject to the outcome of the writ petition.
May I just take one small indulgence, my
Yes.
page number 283, my lord, that bid document. I just wanted to show something to your lordships. Page 283, the bid document of 25 July. Your lordships will come to the end of the document. It says, do you want to show documents uploaded by the bidders to all bidders participated in the bid? It says no. So today I can't even see who has participated, what documents have been submitted.
Why are you making so many people a party?
No, that is also because the reason is I do not know in terms of the previous NIT, my lord, there were a lot of discrepancies that has happened.
Unnecessary why you are making. Here is a case you are only for this. I could have given you a shorter date. Unnecessary why you are making all these
I
people a
can make an
party.
effort, my lord, if your lordships give me a short, I'll make an effort to do serve it as soon as possible. I have no problems, my lord.
Understood, but the question is why you are making these people a party? You are participating in the tender process,
Right.
challenging the eligibility condition. It is between you and the respondents. Once a technical bid is being taken away, you have not participated till now.
Yes.
Neither you don't know who have participated. Why you are making all these people a party unnecessarily?
These people have been part of the previous NIT.
So how does it matter?
They have all been appointed, and my case is that this is a continuation of the same process. So I have to be appointed. So therefore, my lord, I have
Are you insisting that they should not have cancelled the tender,
yes,
but it should have been gone for it
afresh
should have
because,
been
because everything forms one part of it. That is why it is not this NIT is not being terminated. The 12 remains. It is only this 12 which has now come forward. That's that is why it's kind of a splitting of a contract. So 12 remains. If it was a fresh tender, it should have been for the entire 24. Now it is only for the 12. That's my case, my lord. Therefore, I said that this is a completely arbitrary means of getting me out when the other people are already performing in that contract. That is why I was trying to.
No. You are show me the earlier term of the condition
Yes.
by which
Yes.
if it is cancelled, if it
Yes.
is terminated, it will be given to the others. Where is the term?
No, there's no clause. Therefore, my lord, they say you go back to the price bid evaluation.
No.
Would your lordship just give me 1 minute to show that?
No
document?
more. 1
I
minute.
could have
means
shown
I
the
can
clause,
finish
my
it.
lord, where it says.
No. We'll have it after 4 weeks.
Well, I have received the instructions also, my lord, in this matter.
Not here, what to do? Senior is not here. Yes, you tell me.
In fact, my lord, the claim is that the rejection, oh, my lord, he has come.
In this case, my lord, the impugned order, your lordship will find, my lord, at page 39. My lord, what has happened? Pursuant to an advertisement, my lord, the petitioner applied for, my lord, a retail outlet dealership of petrol pump from the, my lord, the respondent number 4. My lord, accordingly, thereafter, there was a draw of lots, my lord, and the petitioner has been provisionally selected, my lord. The lordship will find, my lord.
page 17, annexure 3. Provisionally selected. Thereafter, I have been asked to deposit 50,000. I have deposited, my lord. Then thereafter, my lord, the site verification, field verification was done. Documentation was done. And thereafter, my lord, the authorities, my lord, by impugn order at page 38, my lord, annexure 11, rejected my candidature, saying that, my lord, that the leased out land, my lord, the owner of the leased out land, there are two owners, and all the owners have not executed the lease deed. Now, my lord, the other co-owners, your lordship will find, my lord, from page 31, my lord, 31, and prior to that, my lord, annexure 10, page 29. My lord, I have applied for NOC before the, my lord, the authority, District Commissioner Dhubri, for, my lord, issue of NOC for transfer of land. My lord, it was granted by the Deputy District Commissioner Dhubri, my lord. Govindo Sarkar is the owner, my lord, and and the other co-owners submitted the my lord, the NOC before the authority concerned, saying that they have no objection if the, my lord, land is leased out by Govindo Sarkar. Accordingly, my lord, the district commissioner has issued this permission. No objection certificate, my lord. Your lordship will find annexure 10, page 29. Now, in terms of that NOC, my lord, the lease deed has been executed and registered. Page 31, my lord.
What is this document?
This is the lease deed, my lord. I have taken the land on lease for running a petrol pump over there. If it is awarded in my favor, my lord. I was provisionally selected. I have lordship has seen, my lord. Thereafter, they say, my lord, that because all the co-owners, there are, my lord, two owners, my lord, Govindo Sarkar and Aurobindo Sarkar. As per their letter, my lord, it is there at impugn order, my lord. Now, they say, my lord, since all the co-owners have not executed the lease deed, my lord, the lease deed is not valid. That is their bone of contention. But to that effect, my lord, my respectful submission would be, my lord.
You are making, have you read the guidelines?
My lord, guidelines of brochure, what they are saying, my lord, as per their brochure.
Have you read the brochure?
Brochure, my lord, brochure.
Have you,
with all
Mr. Sen,
restriction.
have you read the brochure before filing the writ petition?
I have, my lord, but
Now
to
tell
that
me,
effect, to that
tell
effect,
me,
my lord.
when it is a case of a lease,
My lord,
what is requirement?
requirement, my lord, is section 105 of transfer. of property.
Forget about that. I'm not as per the brochure.
My lord, brochure is with all respect, my lord, brochure is an internal policy, my lord.
No,
It
these are the
cannot-
terms on which,
My
no.
lord, it cannot override the statutory provisions of law, my lord. Can it be, my lord?
Yes.
Say, my lord, transfer of property Act section 44, your lordship, aware, my lord. Any co-owner of the property is entitled to, my lord, transfer his share of land. My lord, section 44 says so.
Mr.
Now, my lord,
Mr. Sen, kindly listen. It was a advertisement issued.
my lord,
You are to file in terms with the clauses mentioned in the brochure. In the brochure, it is categorically mentioned that There are three types of categories: category 1, category 2, category 3. Category 1 are those persons who are either owners of the land or have lease deeds for a period of 19 years, 11 months. Category 2 are those persons who have a concrete offer that they will get a lease deed or ownership. Category 3 are those persons who do not have anything. These are the categories. Now, as regards ownership, what are the requirement documents which are to be given is given in the brochure. As regards the lease deed, if it is of joint ownership, what is required is that first you need to have a lease deed with another co-owner, and other co-owners have to submit an affidavit in terms with Annexure Roman 3, isn't it? Which is not there in your case. So
It is there.
therefore, you
With all
don't have
respect,
your
it is there,
case.
my lord. It is there with all respect, my lord. My lord, at the time of issuing NOC by the district commissioner, my lord, this, my lord, this no objections.
You are to submit as per Annexure 3 before the authority.
I have, my lord.
Where is that?
Yes, my lord. It is
Annexure 3.
there, my lord. Your lordship kindly see, my lord.
Show me.
My lord, page 23, your lordship kindly have a look, my lord. Page 23. My lord, this was submitted before the authority. Page
Where?
25 is the relevant portion, my lord. May I read, my lord? We are the patta holders of land measuring 1 bigger 2 patta 1, 15.55 letters, dag number so-and-so, patta number so-and-so, situated at so-and-so, district Dhubri, Assam, is recorded in our names along with the co-pattadars, our brothers, namely Govinda Sarkar, late Brindavan Nath Sarkar, resident of so-and-so, 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 enjoying and possessing the fruit land since long time and.
Mr. Sen, I therefore ask you, have you read the brochure? Before making that petition, have you read the brochure?
I have
Because,
submitted
no,
this.
you have not.
Yeah, I have submitted, my lord.
No, this is not the document which you have to submit. See the form in which it is to be submitted. They have to say categorically that we have no objection if this particular lease, and we would not lease or sell this land to anybody. These are conditions which are mentioned in the brochure. Annexure 3. This is not being done. Apart from that, the names which are appears in the Jamabandi are different. Your father, the father name is some Bhavani Sundar.
Bhavani Sundar, yes.
Sarkar. And here in the lease deed, the Govinda Sarkar's father's name is Birendra Nath Sarkar. Where is this?
Govinda Sarkar, my lord, Govinda Sarkar is the son of Bhavani, my lord. Govinda and Aravinda. As per their letter, my lord. My lord, page 38. Last paragraph, my lord, your lordship will find, my lord. Previously recorded in the name of Bhavani Sundar Sarkar has been mutated in favor of Aravindo Sarkar and Govinda Sarkar by inheritance.
Both being
Sons of
Bhavani Sundar
Bhavani
Sarkar.
Sundar Sarkar. Landholding certificate so and so do not justify Govinda Shankar is the sole owner of the land offered. Lease deed has not been executed by all the co-owners.
Yes, either it has to be executed or have to be given the annexure 3.
NOC is given, my lord. With all respect, my lord, it was given in a form in a manner prescribed in the brochure, my lord. That is, my lord, that is the case of the.
Mr. Chaudhary, what do you have to say?
My lord, this order which has been impugned in this writ petition is dated, my lord, 23rd of June. In the meantime, my lord, another person has been selected, my lord, and third party right has been created, my lord. May I place it on record? The instructions I have received, my lord.
As per category one.
My lord. My lord, down below, Srikanta Karmakar. He has been selected and he has been offered this. So third party right has been created already.
No, this is again, it's not a, he is also given the same thing.
Yes, my.
Where he was. So pursuant to, there was again another lottery process.
Yes, my.
And he must have got it.
My.
And now he has to again formulate all the proof.
True, my.
The process has been initiated. That is what my lord, I have been told, my lord, by my client.
The same process where you became number one in the lottery process,
My lord.
it is now being given to some other person, lottery process.
My lord, but your lordship kindly consider, my lord.
I'm not going
If
to
it is-
consider.
if it is- if
What
it
do
is,
you
my
want?
lord, if it is-
Dismissal
My lord,
or
no.
withdrawal with liberty to regain file? Either of it, taking into account that.
My lord, I will file an additional affidavit to that effect
For what?
for the subsequent development that is.
Are you not required to amend then? You are such a great civil lawyer, you know what to do.
With liberty to file.
That is what. Mr. B.K. Sen, heard Mr. B.K. Sen, the learned counsel appearing on behalf of the petitioner. Mr. M.K. Chaudhary, the learned senior counsel, assisted by so-and-so, appears on behalf of the respondent numbers 1, 2, and 3, na?
I don't know.
1, 2, 3. 1, 2, 3, and 4. 4 also. Respondent number 1,
In
2, 3, and 4.
I'll be appearing for 2, 3, and 4.
2,
2, 3, and 4, my lord, is a by name. That is a difficult.
He has done it by name. Without Malafide being alleged, you have done. 2, 3, and 4. Mr. M.K. Chaudhary, the learned senior counsel, placed before this court an instructions dated 8/7/2025, whereby have placed before this court an instructions dated 12/8/2025, wherein there is a reference to the selection of Srikanto Karmakar on the basis of the lottery conducted amongst the remaining category 1 candidates for the RO dealership between Pasigat HS School and Tomorghat Police Station, Dhubri, Posugao Road, NH 127B, which is the subject retail dealership. Taking into account the same, Mr. B.K. Sen, the learned counsel appearing on behalf of the petitioner, submits that the petitioner would be well advised to withdraw the instant writ petition and file a fresh writ petition, bringing the subsequent events within the purview of bringing on record the subsequent events. Taking into account the above, the said instant writ petition stands closed on withdrawal. However, the petitioner would be at liberty to refile, taking into account the subsequent events. The emails so produced by the instructions so produced by Mr. M.K. Chaudhary, the learned senior counsel, is kept on record and marked with the letter X.
My lord, a copy of the instruction may kindly be
I'm providing it.
furnished to us.
But first, and Mr. Sen, if I am again sitting, either file it after 25th,
My lord.
before 4th September, and get an order. Otherwise, after that, if I am sitting again or before that I am sitting, get on record the brochure. You cannot file this without the brochure because brochure contains the terms and conditions.
Item 9,
deeply
stay vacating.
My pleasure. The respondent has filed their affidavit, lordship. We have also filed their reply. The
Who has filed this case for with the writ petitioner.
I'm the petitioner. I'm the petitioner.
Fantastic. Yes. What is your case?
Lordship, on 24/01/2025, Lordship, NIT was issued. Page 18 is the NIT, Lordship.
In the interim award list in respect of serial number 5 of repairing bazaar at so-and-so, which have been awarded to the private respondent shall remain till the next date. Okay.
Only condition is the page 20.
What are you
Lordship.
challenging here?
Lordship, the condition is page 20, Lordship, 4, clause 4.
Huh?
Lordship, we are challenging the later award list, Lordship, wherein by the private respondent was awarded, Lordship, who is the son of law of the respondent of 4, Lordship.
Huh? He's the son of?
Law of the respondent of 4, Lordship.
The son of the respondent number 4.
Son-in-law.
Son-in-law has been given this contract.
Yes, Lord.
So that is your ground.
Lordship. Lordship, the clause 4 of the NIT, Lordship, whereby the any rate quoted recklessly by the bidder worth less than 10% of the package will be
Clause 4.
rejected.
Any rate quoted recklessly by the bidder worth less than 10% will be rejected and disqualified.
Both petitioner and the respondent of 6 has quoted within 10%. Both are the L1, Lordship. What happened? The selection process had not been disclosed in the NIT, Lordship. That is silent. NIT is silent. So subsequently, a meeting was held on 14/2/2025. Page 23 is the
Oh, both of you quoted same price.
same price.
Then
14/2/2025, a meeting was held. Last date of the NIT is 6/2, Lordship. On that day itself, the NIT was.
Cases more than one LS stands as a L1 bidder, lowest amongst the participate bidder.
Yes.
As the comparative statement of it. Procurement of it.
Lordship, if Lordship, come to page 23, Lordship.
What is the issue involved?
Now they have changed the criteria, Lordship.
The score for financial turnover may be taken as 40% and score for work order may be considered as 25%. Then
Lordship, this is
I
all
know that
initially
the
the
said
proposed
lady
marking
is-
criteria is above, Lordship. Lordship, in the said meeting, the chairman is also present, Lordship. Page 23, serial number 1 is the chairman.
serial number 23. Okay. Chairman,
Yes, Lordship.
Sushanta Kumar Nal.
Page 24, Lordship. Now they have the NIT was, Lordship, silent about the selection process. Now they have a proposed marking pattern was introduced, Lordship. The proposed marking
Cases of
criteria.
multiple demand.
Yes, Lord. Proposed marking order for evaluation of eligible bidder in cases with multiple L1 code.
Plus
So
or-
class 1, for class 1, 40%. For class 1, 40, class 2, 35, and class 3, 30 mark. Whereas in the work order, they have also introduced the work order who has given highest mark. So he will get 40 marks. The second, he will get 35, and third will 30. In respect of financial turnover, whose bidders is financial turnover more, Lordship, he will get 20 marks, second 18, and third 16. In this criteria, Lordship, petitioner will got highest mark, Lordship.
You
Lordship,
got highest mark.
Yes, Lord.
In this, in as per this also.
Yes, Lordship. If Lordship come to,
So you have no problem with this assessment.
but subsequently, this is sense, Lordship.
Ah,
Lordship, handwritten, Lordship, no.
where?
In that page, Lordship, page 24,
Page?
below. Page 24 itself, below.
Chairman Ding, right?
The score for financial turnover may be taken as 40%. May be taken as 40%, and score for work order may be considered as 20% if majority agree. So this was put up before the move. Lordship, it take up my affidavit in reply. File against the.
What is page 27? No commissioner of a board or a committee shall have without the written permission of the state government directly or indirectly any share or interest in a contract lease. This has no relevance. here.
Lordship, it take up my affidavit in reply.
Your
File against
affidavit
the
in reply.
respondent 3, 4, and 5. Yesterday we had filed.
Huh?
Yesterday we had filed.
Okay, got it.
Para Lordship 5.
5.
Yes.
Yes.
That the statement made in paragraph 5 and 0 are not correct. The deponent states that the methodology that was specified was a marking pattern wherein 40% was earmarked for work order and 20% work earmarked for financial. The admitted fact as admitted by the respondent 6 is that once the evaluation criteria was fixed without citing any reason, the same was completely changed. The deponent states that the same has been done only to favor the private respondent. Had the original criteria been maintained, the deponent would have been the entitled bidder for the award of the contract work. It is pertinent to mention here that respondent 6 and the written petitioner being the class 2 contractor, both is entitled for 35 marks. Both are the class 2. In respect of class order, the writ petitioner has submitted similar nature of work order of rupees 16,93,000, whereas the respondent number 6 has submitted the work order of rupees 8 lakhs. As such, as per the earlier marking pattern, the writ petitioner is entitled for 35 marks and the respondent 6 is not entitled for any mark. Whereas in respect to the financial turnover, the average financial turnover of respondent 6 is so and so, whereas the respondent petitioner's financial turnover for average 3 years is less. And as the respondent 6 is entitled for 18 marks as per the earlier marking pattern, where the petitioner is not entitled for any mark. Place thus the writ petitioner is entitled for 70 marks as per the earlier marking pattern, and the response 6 is entitled for 53 marks. The efforts have been demonstrated from the following fact. The class 2, the Shubham De is the respondent 6 logic. Both are the class 2. That's why they will get 35 marks each. Work order, the petitioner has submitted 16 lakhs, whereas the
just 1 minute. Why you are saying that he's 0 here?
Because
in work order?
Because I have submitted 16 lakhs.
Then why
He
8
has-
lakhs is 0?
Yes, he has only 8 lakhs. So highest will be taken into consideration.
Where?
As per the earlier marking pattern.
Earlier at page 24.
Yes, 24.
24 it says first rank is 40 marks.
40 marks.
Second is 35.
Yes, but
And
the
third is-
first is for the class 1. We are for the class 2. That's why class 2.
The class 1 is okay. Class 2 is 35.
35.
Understood.
Everything
Then
work order
40%.
also, since both are the class 2. So Lordship may taken into consideration regarding the class 2. So work order also 35 marks for the we are fall in the category of class 2. So in rank also we are for the second one.
So he gets 35 and what is this? By rank mean what?
Rank is class 2.
Huh?
Class 1, class 2, class 3.
No.
Yes.
The person who actually highest number 1 as per the work order 40%. What is this?
40% for the class 1 contractor.
So this is 40,
The
40 and 20.
first row is for the class 1.
Okay. So 40% mark will be given on what class you are.
Class 2.
So both of you are class 2.
Class 2.
So 35 marks.
So second row is applicable.
Second is for work order.
That is also for
Then
the 30.
any person who is the number 1,
He will get 35.
gets 40 marks.
For the class 1 and in respect of class
And the second person will get 35.
35 marks.
So he will get 35, not 0.
No. In respect, the second row is for only for the class.
No. Second row is for only for this one. This is only for this one.
No.
First, second, third, it is
As
given.
per my
vague,
instru-
na?
as per my
So
instruction,
here it will 40 and 35. Then financial turnover is, yours is much more.
no, his
So again, you get 20 and he gets 18.
financial turnover he's much more. We have annexed the documents.
Huh?
He is
Oh, his is much more.
much more.
So he gets 18.
18 lots.
You can't have 0. No, it can't be like that. I think you have to add, I think this is 40, 35 both, because it is same.
Same.
In respect to work order, the person who is highest will get 40 and the second will get 35. And in respect to the financial turnover, who is highest will get 20 and the other one will get 18.
But as per my instruction, Lordship, the
Who has given you that instruction?
second-
The petitioner.
Yes.
Not as per the petitioner. You do it by yourself. Calculate it. How much you get?
Then also, Lordship,
For 35 plus 40, 75 plus 18. How much? Because it has to be done in 100, na? You can do that. 75 plus 18 is how much?
93 Lord. 93.
So you get 93. He gets 35 plus 35, 70, 70 plus 20, 90.
19.
So this is how you do it. So yours is 93. Then also you get a better one.
But now
How do you put 0? You can't put 0. Anyways, yours is 93, he is 90. Now what happened?
Now,
However,
now
after the
criteria,
unilateral change of the marking system at the behest of the chairman Ding, marking is 35. Work order, what he has done, so he has put this 20.
yes, okay. Now,
Okay, he has changed it, na?
Yes.
So instead of financial turnover, he has put it 40% and this he has put it 20. Okay, now I get it. Okay, so this has been done by the chairman.
chairman, because chairman is he is present, lordship, page 23, and the same was placed before the chairman. So ultimately, chairman has the approved. So chairman is he has ultimately his behest, lordship. This was.
Then
Now, award of the list has been published, lordship, that has been said by this honorable court. And in respect to the lordship is take up the.
I am for the private
lordship
respondent.
take up the affidavit in opposition to response 3 and 4.
I've got the idea. Let us hear him. Your case therefore is, both of you were equal bidders. So they adopted the policy subsequent, wherein it will be 40% for the class, 40% for the purpose of work order, and 20% for the purpose of financial turnover. That equation is taken, yours is 93 and his is 90. On the other hand, what is being done is the chairman changed it and made it 20% for work order and 40% for the financial turnover. And thereby he gets 40 and 35 you get 35. And on the other hand, in the other one, you get 20 and he gets 18. How much then it is? 35, 35, 70, 70 plus 18. 70 plus 18. Yours becomes 35, 70 plus 18. 88. And he gets 35, 40, 75 plus 20, 95. Otherwise, he gets 95 as per this, and you get 88. Yes.
My lord, as per the because there were tender in respect of many works, my lord, where there was a condition, then 10% plus minus bidder can quote, my lord. So, my lord, normally maximum bidder quotes 10% minus, and therefore there are on many in respect of many tenderers, my lord, L1 is more than 1, my lord. So to tackle up that situation, my lord, the tender committee decided that a methodology should be adopted for marking data. So initial methodology was adopted, page 24, my lord. The work order 40%, financial 20%. That was by the tender committee where the chairman was present. But subsequently, my lord, the expert committee, if the down below, if your lordship see down below, my lord, the expert committee consisting of technical persons, my lord, they have endorsed a note to the chairman. That decision was not taken by the chairman. They have endorsed a note to the chairman that the scope for financial turnover may be taken as 40% and scope for work order may be considered as 20%. They have reversed it, my lord, and it has been put up before the chairman. If majority agree, my lord. So, chairman was not a party to that decision, my lord.
Then the party, who agreed?
Yes, my lord.
Then did the chairman agree or not?
My lord, the condition.
Did the chairman
No,
agree?
condition was if majority agree. Majority of the members agree. That's why, my lord, it has been done. Page 24, if your lordship produces page 24.
Understood, if majority agree.
Yes, my lord. Majority of the technical committee members.
Who has put this?
These are the signatories, my lord.
If all the persons have already signed it.
Yes, my lord.
Then Then where is the question of majority agree? If majority agree, means everybody has agreed.
Yes, my lord.
Then where is the question of you writing if majority agree?
Yeah, that is, my lord, but it is
It's the
not
way
done,
of writing.
it is not done by the chairman, my lord.
Understood, it has been put up to the chairman.
Yes,
If
decision
it
has
is
been,
put up to the chairman by all,
yes.
was this signature who has put up?
These are the signatories, technical member.
If all these people have put up,
Yes, my
then
lord.
why did they write if majority agree?
My lord, there may be, because these are technical persons, my lord. These are the technical persons, my lord.
So the technical person say that let us not go by the technicality, the technical parameters, which are particularly work order or class,
Yes.
but let us go by the financial turnover.
No, financial turnover and work order. And
No, understood. Work order has been given less value.
yes, my lord.
What they have done is they have given more value to the technical, the
Yes, my lord.
financial
In
turnover.
respect of
Why?
all the works, because there
Why
are,
have you- So your answer has to be why you have given importance to the financial turnover. Why? You have formulated this. You have
lord.
changed this.
Yes, my lord.
Why? Why you have given importance to the financial turnover?
Yes, my
and
lord.
not
That
for
will
it?
be answered by
You are
the,
appealing for whom?
for the private respondent, my lord.
I
Yes,
don't
my
hear
lord.
the private.
Yes, my lord.
Because the finance is the main aspect of executing the work, Lordship.
Huh?
There's a finance is the main.
So why have you mentioned that the finance, you changed it to financial?
And that
turnover?
decision was taken by the expert committee, Lordship. In this executive.
So if that be so, why have
Each-
you
each
mentioned
exhibit-
if majority agree when you are signing everyone, or who has put it
Since
up?
they were present before, in the meeting, that's why they have endorsed their signature, Lordship. Since they were present in the meeting, that's why they put
So
their
why did
signature.
you put if
Ultimate decision was
majority agree?
taken-
Means who has put it up to the chairman?
All the members present, technical committee
So
members.
therefore, why did they put if majority agree?
Ultimate decision was taken by,
No,
they have suggested, Lordship, the technical committee suggested to the chairman that if the financial thing is taken, give more weightage, then
So
it will
therefore,
be better for
if it
execution.
is being suggested, has the chairman given a decision? If it is being taken as suggested, has the chairman given a decision? Or could the
Chairman just
chairman give a
endorsed it.
decision in the case of his son-in-law?
Chairman just endorsed the decision of the majority, Lordship.
Where is the chairman's signature in endorsement?
In the initial meeting in the meeting of 14th to 25, chairman was present.
So,
On the next-
no, this was being placed on 17 to 2025.
Lordship, on
Where
that
is
day,
the
chairman was not
endorsement of the
present.
chairman?
Chairman not present on that day.
So therefore, there was no endorsement. When this is a note which is being put up.
Put up, Lordship.
But who has made the earlier one? At page 24.
Earlier was made by the chairman.
Same people.
Chairman. Lordship.
Same people.
Same
Then
people.
why did then you have placed it to the chairman? But has
Lordship.
the chairman acted on it?
Chairman acted on it, because
Where is it?
they given the decision based on the majority decision, work order issued in favor of this private respondent. Lordship.
Huh?
Based
No,
on
no.
majority
Where is the
decision,
decision of the chairman accepting this evaluation?
that is in the file of the Lordship.
Hello, produce the file. We dismiss his
Office record.
application for
Lordship.
vacating.
This is in the office record, Lordship. Because decision was not taken by the chairman. It
So
was taken-
you say,
majority
are you saying that decision has been taken or decision has not been taken?
decision was taken by the chairman.
By the
Since-
chairman.
Since majority
So
was
now
agreed,
tell me if the decision has been taken by the chairman, could the decision have been taken by the chairman when his son-in-law was present? Of changing the criteria when earlier it was something else? And did you take this decision after who is there? When was this decision taken? On 14/2.
14/2.
Why the change in the decision on 17/2? Don't you think that you should, when you are putting a clause that below 10% it will be rejected, everybody would be quoting 10%? So therefore, This only happened in only one tender or how many tender? Only one.
Not, there were so many tenders, many tenders, eight tenders. were-
So in all
In all
tenders,
cases-
did you apply the same?
All cases, this has been adopted, this methodology is adopted. Lord Sir.
So let us see
not-
where is the evaluation done subsequent date.
Altogether, there were eight tenders.
Huh?
Issued, altogether, there were eight tenders issued by this NIT. In other cases, same methodology was adopted.
How do I know? Produce the book. Chairman has not done that.
We have I have in my
And who has enclosed this? Who is this annexure affidavit filed by the respondent number 3, 4, and 5?
chairman is filed. Lord Sir.
Okay, the chairman has filed.
Lord Sir.
Now read it. Kindly come to page 46. Read what is given out there, the terms and all these things. Let us read it. Can you read it?
Lord Sir.
Read page 46. That is the part of your annexure or page 19 of your affidavit in opposition. Can anybody read it? Huh?
Number
Designation is.
pagination is something different. Lord Sir.
Page 19 or annexure 1 to the affidavit in opposition filed by the respondent numbers 3, 4, and 5.
Lord Sir. See tender and
Read it.
See, from the beginning, Lord Sir.
Huh? Now
See-
read the next page, the second page. Notice inviting tender, the next page. Read it.
Qualification, intermediate, the funds of the the following. Up to date registration certificate, of building division for building mark work from the.
Okay.
Up to
Then you
date.
can read it from yours.
Lord Sir.
Take on video. Read it. You can read. From here you read it. Let us hear from here. Is it legible?
Lord Sir.
Huh?
Beg apology, Lord Sir.
Is it legible?
Filing, no.
Then I think this stay order should continue till the period is over. What is the period? I think this should stay. When these young people do like this, I think this should stay for another 10 years, 2 years. What is the period of the contract?
Period.
This type of action on the part is cannot be there.
Lord Sir.
Timing completion, Lord Sir.
Huh?
60 days time completion. Time of completion. Time of completion.
60 days, Lord Sir.
60 days.
What,
In both
have you mentioned in your affidavit why you chose the further this? As per the proposal, the scope of the work was considered as 40 financial turnover. However, some of the members of the act suggested that the scope may be given, taken on 40% and work order be given on 20% subject to consent of the majority of the people. The comprise of the members of so and so, so and so, so and so. Being by the decision and the resolution of the majority to keep up the year was open and more acceptable and with the response. Okay, let me come back. Kulta, your case is bad. Why I'm saying your case is bad is Mr. Gupta has not been able to say what is actually there in the affidavit. This was not a decision. It was a proposal being submitted. And this proposal was not accepted and they made this change. This is how it. You should make that submission.
Affidavit is copied from
He has
the
not read it paragraph 5. Mr. Gupta, you should prepare. Don't come up with like this. And first of all, we are imposing a cost as a deterrent upon you of 50,000 for giving ineligible. These are all cost on deterrent.
For that, Sir Lordship.
No, no.
That
Minimum 10,000.
the clerk has.
And subject to non-payment, if you don't pay within 7 days, this will be your license would be, you shall not be here. I'll put it on there. Now, as a deterrent, this has to be done. That day I have to impose 25,000. Today I will be lucky to get only 5,000 or 10,000. 5,000 is too less for you.
Lordship.
Imposing a cost of. But Mr. K. Kulkar, the learned counsel appearing on behalf of the petitioner. Mr. MTT appears on behalf of the respondent number 1 and 2. Mr. KL Gupta appears on behalf of the respondent number 3, 4, and 5. And Mr. Pipipura appears for respondent number 6. The petitioner is aggrieved by the action on the part of the respondent authority respondent municipal board in awarding the contract pertaining to repairing of the Bazaar Road and construction of the PCC Road at Dhing Bazaar. On the basis of a yardstick being applied, which the petitioner alleges to be unfair and unreasonable, violating the mandate of Article 14 of the Constitution. The materials on record show that a notice inviting tender dated 24/1/2025 was issued by the respondent number 5 from eligible APWD contractors, bracket class 3 and above, in respect to various works coming within the ambit of the 15th FC United Grant second installment for the year 2023-24 during the year 2024-25. The present writ petition relates to two works which are at serial number 5 and 6 of the said notice inviting tender. That is, repairing of Bazaar Road at Dhing Bazaar and construction of PCC Road at Dhing Bazaar. The notice inviting tender further stipulated various tender conditions. But relevant for the purpose of the instant case is clause number 4 of the said notice inviting tender, which stipulates as hereindunder, 4 will be any rate quoted recklessly by the bidder worth less than 10% of the package will be rejected or disqualified. Next. The petitioner, along with various other bidders, participated in respect to the two works as aforementioned. The admitted facts show that the respondent number 4, the petitioner as well as the respondent number 6 quoted the same rate, which was, what is the rate?
Below 10.
Below 10.
Below 10.
Huh?
Below 10%.
No idea.
17 lakhs, 19,900.
17 lakhs?
19,900.
19,900.
And
Pusto. Isn't it same?
and other is 16 lakh 81,200. Two works. 70 lakhs,
What
19,900.
paper you are looking into? Give it to me. The materials on record, as well as from the submission of Mr. K.L. Gupta, the learned counsel appearing on behalf of the respondent number 3 to 5, shows that both the petitioner and the respondent number 6 quoted the same rate. In respect to the work pertaining to repairing of bazaar at Dhing Bazaar, the quoted rate of the petitioner as well as the respondent number 6 was rupees 17 lakhs 19,900. And in respect to the construction of the PCC road at Dhing Bazaar, the quoted rate was 16 lakhs 81,200. This goes further finds it very pertinent to observe that in the notice inviting tender dated 24/1/2025, did not contain any clause as to how the tendering authority would decide whom to grant the tender in the circumstance when there are more than one L1 bidders. It is further taken note of that a meeting was called on 14/2/2025 of the members of the tender evaluation committee, no, meeting was called on 14/2/2025. Of the tender evaluation committee, wherein amongst the various members, the chairman of the Dhing Municipal Board, that is the respondent number 4, was present. In the agenda of the same meeting, one of the items which was fixed to be discussed is what course of action was required to be taken when more than one bidder stand as L1 as per the comparative statement of the financial bids. The dispute in the present case arises therefrom, inasmuch as on 14/2/2025, a proposal was submitted in the meeting of the tender evaluation committee as to how to evaluate the eligible bidders in case with multiple L1 bidders. The proposal which was submitted is reproduced herein under page 24 type chorus. Next. It further appears that on 17/2/2025, five out of 8 members of the tender evaluation meeting proposed a different yardstick to be applied. The proposal which was submitted by 5 of the members were that instead of having 40% marks on the work order and 20% of marks on the financial turnover, it should be the otherwise, that is 40% marks on account of financial turnover and 20% marks on account of the work order. Next. The resultant effect was that the respondent number 6, having scored more marks than the petitioner, both the works in question were awarded in favor of the respondent number 6. The petitioner, being aggrieved, has therefore approached this court by filing the present writ petition. Next. The allegations which is contained in the instant writ petition are that the respondent authorities have changed the yardstick after it was proposed on 14/2/2025 in order to accommodate the respondent number 6, who was the son-in-law of the respondent number 4. The second reason for which the second ground for taken is that the change which was proposed on 17/2/2025, 25, to the proposal made on 14/2/2025. Was changing the yardsticks at a later stage. After coming to learn that the respondent number 6 after coming to learn that the contract has to be awarded in favor of the petitioner. And as such, such actions are unfair, is not fair or transparent, and resultantly in violation of Article 14 of the Constitution. Anything more?
Lordship,
Huh?
judgment, I can refer Lordship, AK Cripax judgment, Lordship, Cripax judgment, Lordship, as well as the Doctor Association.
So associates, how will it apply? And the other one,
Cripax judgment, Lordship,
what
regarding.
does it say?
Regarding the in presence of the respondent of four, Lordship, regarding the presence of the respondent of four, Lordship, influence.
It is further seen from the materials on report that after the filing of the writ petition, the court, by an order dated 28/3/2025, directed, while issuing notice, directed that the award list in respect of serial number 5 and 6, that is repairing of Bazaar Road at Dhing Bazaar and construction of PCC Road at Dhing Bazaar, which have been awarded to the private respondent number 6, shall remain suspended till the next returnable date. The interim order, in the meantime, have been extended from time to time. The record reveals that the respondent number 2, 3, 4, and 5 had filed an affidavit in opposition. Wherein, at paragraph number 5, it was stated that in view of there being more than one L1 bid, a meeting of the Tender Evaluation Committee was held on 14/2/2025 by the Dhing Municipal Board, wherein various issues were discussed, including the issues of having more than one bidder, emerges as L1 as per the comparative statement of the financial bids. It was stated that a proposal was submitted that the scope of the work was considered to be given weightage at 40% and a financial turnover as 20%. However, some of the members of the Tender Evaluation Committee suggested that the scope of the financial turnover may be taken as 40% and work order be given weightage of 20%, subject to consent of the majority of the persons of the evaluation committee. It was further mentioned that the Tender Evaluation Committee, comprising of members from the different fields, went as per the suggestions so made by the majority, and the respondent number 6 was found more suitable. And as such, the said works were awarded to the respondent number 6, and letter of acceptance were issued to the respondent number 6 by letters dated 4/3/2025. The said affidavit so filed by the respondent number 2, 3, and 4, 3, 4, and 5 was filed by the chairman of the Ding Municipal Board, wherein he had stated in paragraph number 7 that he had not taken part in the final decision-making authority. Now, he was not a part of the final decision-making authority, and the methodology adopted by the tender evaluation committee was not reversed by the deponent. It was further stated that a change of methodology was proposed by the technical evaluation committee comprised of experts from the different fields, which has only been endorsed by the deponent without having any say in it. It was further stated that a change of the methodology was proposed by the majority members of the technical evaluation committee. This court at this stage, however, finds it very pertinent to observe that the enclosures enclosed to the affidavit in opposition were not at all legible. More particularly, Annexure 1 to the said affidavit in opposition. Irrespective of the said document being not legible, the counsel for the respondent number 3, 4, and 5 had certified the same to be true copy. This court further takes note of, further finds it pertinent to observe that when such documents which are being filed which are not legible, the registry also should not have accepted the same. The record further reveals that the petitioner had filed affidavit in reply to the affidavit filed by the respondent number 3, 4, and 5, wherein the petitioner had given the details as to how the change in the yardstick, which was change in the yardstick proposed, wherein the yardstick proposed on 14/2/2025 and the change in the yardstick on 17/2/2025 had impacted the petitioners right to be granted the contract in question. It is also pertinent to mention that the respondent number 6 has also filed an affidavit in opposition, which are similarly drawn in the lines of the affidavit in opposition filed by the respondent numbers 3, 4, and 5. This court is not reiterating the statements made, the contents of the said affidavit in opposition for the sake of brevity. Reply to the said affidavit in opposition has also been filed by the petitioner. In the backdrop of the above, let this court take note of the submissions so made by the learned counsel appearing on behalf of the petition parties. Mr. K. Kulita, appearing on behalf of the respondent, petitioner, submitted that the presence of the respondent number 4, who was the father-in-law of the respondent number 6, in the meeting held in the meeting, and the roles of play have resulted in the change of in the yardstick on 17/2/2025. He submitted that as per the settled principles of law, as have been held by the Supreme Court in the case of A.K. Kripak and others versus Union of India, reported in 1969, 2 SCC 262. Which paragraph?
15 and 16.
Huh?
15 and 16.
Wherein the Supreme Court held that the presence of who was this fellow? Nasir Bund. Who was he?
He is the forest commissioner.
Relying on the judgment of the Supreme Court in the case of A.K. Kripak versus so and so and so. The learned counsel submitted that the presence of the respondent number 4 in the selection process in the tender evaluation committee have rendered the decision
Is the
made in favor of the petitioner, in favor of the respondent number 6, violated of the principles of natural justice. Per contra, Mr. K.L. Gupta, the learned counsel appearing on behalf of the respondent number 3, 4, and 5, submitted that pursuant to the agenda for calling for the meeting of the tender evaluation committee, a evaluation criteria was proposed. This proposed evaluation criteria, however, was not accepted, and another proposal was submitted on 17/2/2025 by 5 out of the 8 members, wherein they suggested that instead of 40% marks to be granted in the category of work order, 20% marks should be given, and in respect to financial turnover, 40% marks should be given instead of 20%. The learned counsel further submitted that what has been done was a majority decision comprising of various members from the field. And the respondent number 4 and the chairman of the Ding Municipal Board were nowhere involved in the said decision, inasmuch as the said decision was taken on the basis of a majority opinion. He therefore submitted that the question of bias, which have been made the fundamental, which is the pivotal contention made by the petitioner, do not arise. Anything more? No. But 20,000. Mr. B.P. Bora, appearing on behalf of the respondent number 6, adopted the same argument which have been made by Mr. K.L. Gupta Analysis and determination. From the materials on record, it is seen from the above analysis, from the details enumerated herein above, it would be clear that the dispute which have arisen in the present case is on account of the evaluation criteria so adopted. There's no denial of the fact that on 14/2/2025, the evaluation, there was a proposal being submitted, the details of which have been quoted herein above. Subsequent thereto, on 17/2/2025, the 5 out of 8 members of the tender evaluation committee proposed that instead of 40% marks being given in respect to work orders, 20% marks should be given, and instead of 20% marks given in the financial turnover, 40% marks should be given. First, this court further finds it relevant to take note of that the 5 members who have proposed were not the chairman, did not include the respondent number 4, who was the chairman of the Dhing Municipal Board against whom the allegations have been made. Further to that, the proposal so made on 17/2/2025 was as to was accepted by a majority decision. This court further finds it pertinent to take note of that the said proposal was made on 17/2/2025 by various persons in different fields, that is the executive engineer PHE, Dhing Division, comma, the deputy director town and county planning, comma, the executive engineer, what is this MAD?
Municipal Administrative Department.
Municipal Administrative Department, Dhing, Nagaon, Dhing na?
Nagaon, sir.
Municipal Administrative Department, comma, Assistant Executive Engineer PWD, Dhing Territorial Division, and Assistant Executive Engineer PWD, Dhing Territorial Division. These are the same, no?
Rupohi at Samaguri Territorial Building. Rupohi at Samaguri Territorial Division Building.
Okay, Dhing Assistant Executive Engineer PWD, Dhing Territorial Division.
Rupohi at Samaguri Building Division.
Subdivision.
Paragraph 5, sir.
And Assistant Executive Engineer PWD, Dhing, Rupohihat, and Samuguri Territorial Building. First. This court further finds it pertinent that the counsel for the petitioner, though, submits that the said decision to change the criteria have been made at the instance of the respondent number 4. But it is very pertinent to observe that the proposal was submitted only on 14/2/2025 when the respondent number 4 was very much present. However, on the said date, the said proposal was not accepted. The said proposal was not accepted. And it was subsequently on 17/2/2025, 5 of the tender evaluation committee members have proposed the change in the criteria. In the opinion of this court, in the opinion of this court, as there was no decision so taken, no decision apparently taken, no decision taken by the chairman of the Dhing Municipal Board solely, but it was a decision taken by the majority. The said decision under no circumstances can be said to be in violation to the principles of natural justice. This court further finds it relevant to observe that the entire case of the petitioner is based upon the proposal being submitted on 14/2/2025. However, the records so placed before this court do not show that the proposal so submitted on 14/2/2025 was at all accepted by the tender evaluation committee. Rather, the proposal being submitted on 17/2/2025 by the majority, by 5 out of 8 members of the tender evaluation committee, shows that there was some decision taken. Next. This court also finds it very pertinent to observe that there has been allegation of bias being made against the chairman of the Dhing Municipal Board. However, that person have not been arraigned as a party to the instant proceedings. It is a settled principle of law that when allegations of bias as well as malafide are made against the person, malafide on facts are made against an individual, the person, the office cannot be made a party. The party has to be the individual. On this count also, the petition ought to fail. Considering the above, this court do not find the present case to be a fit case for exercising the powers of judicial review, for which the writ petition stands dismissed. Before parting with the record, this court finds it very pertinent to observe that the counsel appearing on behalf of the respondent number 3, 4, and 5 had certified a document to be certified to be true, which was completely, which is not legible. Considering the above, this court imposes a cost of rupees 10,000, 10,000. 10,000 upon Mr. K.L. Gupta, the learned counsel appearing on behalf of the respondent number 3, 4, and 5, to be deposited before the registry of this court within 7 days from today. This cost is being imposed as a deterrent so that in future such occurrence is not repeated. The amount so deposited by the amount of costs so directed to be deposited before the registry shall be then transferred to be disbursed to the district level services authority, Kamrup Metro. It is observed that if this amount of rupees 10,000 is not deposited within the period as stipulated above, the matter be again placed before this court. Then I'll go ask you to be done to back interim orders can begin. দেখুন ঘুরাই দিও। Mr. K.L. Gupta, you take those two papers.
Item 51, fixed at 2 p.m.
Me please. Sir.
Yes.
So the petitioner is aggrieved by the rejection for application on the ground that the lease deed was not executed by the co-owners, Miller. On the contrary, Miller, the lease was executed, the lessor purchased the plot of land of 4 bigha, Miller, solely, Miller, and thereafter has executed the lease deed for 4 katha 12 lessors by way of a registered lease deed. Now the ground of rejection that your lordship will find as page 59. The petitioner was selected, she was asked to submit the security deposit, and thereafter some more
That has
documents.
no reasons. Yes.
Page 59.
Hmm.
Serial number 3. However, we have not received the required documents from you within the stipulated as detailed below. All owners of offered land have not executed the lease deeds, and as per DSG 2021 clause 4 Roman 6A of the such lease deed is treated as invalid. Now your lordship will kindly see the clause value. The clause your lordship will find.
First of all, how much land did you offer?
I offered 4 katha.
Huh?
4 katha 12 lessor.
You offered 4 katha 12 lessor.
Well.
And how much was the land leased out?
No, leased out was 4 katha 12 lessor. The lessor acquired by way of purchase 4 bigha. Out of that 4 bigha, 4 katha 12 lessor was leased out.
To you?
To me.
Lessor. Who lessor?
Lessor is Raju Sharma Malot. He purchased 4 bigha 12 lessor. And out of that 4 bigha.
Where is that sale deed?
That sale deed is not there, Malot.
Then what is this? Your entire business is gone.
No.
They are saying that whose name appears out there in the year.
So
how many people are there?
Jawamandi Malot will kindly say page 52.
What is it?
Page 54 is the vernacular Malot.
25. So 4 bighas.
4 bigha.
Then, and of these 4 bighas, Mr. Kaushik, I don't understand. Why haven't you brought that sale deed? How will a person know that it is within that boundary?
No, the lease deed, my lord.
Lease deed understood.
Yes.
You see, they are saying, what are they saying? Hey,
Sir,
look
they
here,
are-
there are many co-owners. They are saying on the basis of the
The patadas.
patadas.
Patada.
Now, out of that, a sale deed has been executed in favor of your vendor of 4 bighas.
4 bigger.
The 4 bighas will have within its boundary, isn't it?
Yes.
If it has it within its boundary, so isn't it required for you to bring that sale deed to show that these 4 kathas of land is a part of this bounded land? And as such, the question of there other persons being there does not arise.
Right, in fact, if your lordship will kindly see, the land that was purchased by the lesser, that is 4 bigha, that your lordship will find page 54, the my lord, the entry.
Mr. Counsel,
I understand, my lord. I understood, my lord.
you
that-
want to go by this? Okay, let me dispose of now.
No.
Heard Mr. B. Kaushik.
In fact, my lord, in
I
the,
dismiss it.
my lord, may I
No
just-
case. No,
No, I'll
case.
bring that sale deed, my lord.
No case. I'm vacating the interim order. You go ahead. No.
Your lordship will kindly see.
No,
the-
nothing doing.
by
I
way
don't
of the-
understand. But
No, I
see, what
understood.
is the basic case? You
There are
have
no
delayed this
multiple
matter
owners.
from 2024 without coming into account this. From that particular, what they are these people saying? The people are saying that look here, from that particular patta, from the particular record of rights, this patta has various lands. Your case has to be these 4 katha 12 lechas is within the 4 bighas of land which have been purchased. Now, if you don't bring that, if there is no statement in your petition to that effect, what remains?
No,
No case.
The statement is there, my lord.
I'm not going to extend the interim order.
My lord,
Okay.
statement is there. In
Leave
fact, my
the
lord,
matter. You want time?
I,
Okay, leave the matter after.
in fact, my lord, now the land is partitioned also.
This court is not inclined to extend the interim order. Yes.
And the interim maybe. Lordship will give me 2 days time and I'll bring.
No.
Paper.
Not inclined.
My lord, I've made a categorical statement in my petition.
Where?
My lord,
What did you say?
my lord.
Mr. Kaushik, I hope you know the difference between
My lord,
a writ petition and a plaint. A writ petition and a plaint, you are aware of the difference? What is the difference? You are such a senior lawyer, let me understand. Also. What is the difference between a plaint and a writ petition?
my lord, the plaint needs only pleadings, my lord.
And writ petition?
The annexes, my lord, with the documents.
The pleadings?
In support of that pleadings.
Evidence, not pleadings. Pleadings,
Supported
evidence,
by evidence.
everything. Where is it?
That I'll bring.
Can you prove by way of section 91 when it is a document by way of a pleading? No, can you? Then the case is not bad. We should dismiss it
I'll bring that, my lord.
on this block.
I'll bring that because there is a categorical statement that amongst that 4 bigha, this 4 katha, 12
Okay.
plus hours.
5,000 cost. Hello. Cost on 5,000.
No, in fact, now subsequently,
5,000 cost on 6 weeks. Which today the matter is being taken up. You have not brought that fundamental document. Your statement which is there, I cannot look into it because that is not a base on any document. Now the question is whether the 4 katha is included within the 4 bigha. How do I know? Tell me, how do I know?
my lord,
Show me. No, prove it. How do I know from your documents? If 4 katha 12 lecha is included within the 4 bighas, we have to believe them. They are holy God.
not the schedule of the lease deed, my lord.
No, understood. But whether the schedule of the lease deed is a part of that sale deed, where is it?
So the schedule of the lease deed shows, my lord, the other portion of the owner's land, my lord.
Understood. But how do you know that it is a part of the sale deed?
I'll bring that up.
You are
I'll
asking for time.
Yes.
Cost of 5,000. You want time or this court fits after 6 weeks? No interim order.
Let it be after 2 weeks, with
2 weeks with cost. So the matter was supposed to be taken up on an urgent basis, taking into account that there is an interim order operating since 27/6/2024. So considering the same over there. However, Mr. B. Kaushik, the learned counsel appearing on behalf of the petitioner, seeks for an accommodation to file an additional affidavit. List the matter again. When?
anything.
When I'm not there, better off. On 3rd of September 2025. Interim order passed earlier shall continue.
Production list item 1 for motion.
Yes, what is this case?
Lordship, the College of Aeronautical
Who is
Engineering.
appearing here on the other side? Union? Mr. S. Roy, where is he? You are union? Oh, you are there? Oh, you are there. Have you served a copy?
We have not informed us regarding unlisted lots.
Oh, this has not come. List of the any production list. Okay, have you been served a copy?
Regarding service of copy, I have done. Otherwise, in unlisted matter, it is the duty of the petitioner to inform the when copy was served. It should be mentioned to
You
the
mentioned it. Let us see the notice which have been issued. Notice.
He can serve it, but otherwise he is not informed regarding lordship in unlisted. Otherwise, it was come to our.
Let us, what is, just let me have a look at. Yes, what is your case?
Lordship, the College of Aeronautical Engineering, which is near to the airport. It is, I have established it in 2009 as per the civil aviation requirement. The ministry, under Ministry of Civil Aviation, that is DGCA, Lordship. I have that DGCA rules and regulation.
Now, where is the order you are assailing?
Lordship, it is like I have been being an owner of the college. Being the owner of the college, I supposed to appoint or nominate accountable manager, Lordship. So accountable manager from the beginning of the college.
No. I'm asking you, where is the impugned order?
That is like acceptance of accountable manager. Again, they are reviewing and such a way. I have heard last evening, Lordship, they are changing the accountable manager to another person. Being a proprietor of the college, I am in total dark, Lordship. And I have been I'm communicating with them, and they are not disclosing anything, and they are hiding the official document, Lordship. That is why last evening also I have sent a message to join the DZ.
You are the accountable manager.
I'm the accountable manager. I'm also the proprietor, Lordship.
Continue the acceptance of the petitioner as accountable manager of the College of What is this college? College of Aeronautical Engineering is what?
It is the aircraft maintenance engineering. We used to teach to the student, and that is as per the ICAO, International Civil Aviation Organization. The entire globe, 192 country are the member of ICAO. And in India, Government of India is the member, and Government of India approves the colleges across the India, all over the Indian. So in Eastern region, I am the only one. And this is the aircraft maintenance engineering only approved by the DGCA only, not by any UGC or AICTE, Lordship.
Now, what role do these people have to change the accountable manager?
That is the Lordship, as per the norms, as per the civil aviation requirement, it is clearly stated, Lordship.
Appointment of accountable manager, you do it.
Lordship, I'm
You have earlier appointed somebody else.
somebody else because
Now you are the accountable manager also.
again, Lordship, last to last year,
No, kindly come to page 20.
yes, Lordship.
So you have appointed
I
somebody.
have appointed in between because of my ill health and I had some land problems.
Then you have given it to somebody else. What is this the deed of declaration and here?
Lordship,
The accountable
again,
manager of so and so dealing with so and so and so and so.
Lordship, that is the
Whereas
requirement of the
said in
CR.
relation to the Iman is presently running the first party at the rented premises and so and so, whereas considering the health condition is facing difficulties on the Iman, he has also made critical visits to the campus where he is fully convinced regarding NBA so and so. And based on these measures, the board has agreed with the second party to hand over. Therefore, said approval issued by the EI in respect. Now you want to hand over to somebody else?
Lordship, that time since I was sick and I could not perform the duties and responsibilities of the as accountable manager.
Then?
So again, I have requested DGCA, that is page number 42, Lordship, Annexure 9. Page number 42, Lordship. And they have accepted me again. Page number 50, Lordship, their communication.
And these accountable managers are appointed for how long?
Lordship, as in when it is on my wish, Lordship.
No, this is being appointed on here with and in the attachment, please find the acceptance of so and so as accountable manager in the list of effective issued by the competent authority. They shall be responsible for compliance of requirement as laid down in the so and so. It intimated that these letters as stated above may have been quoted to the acceptance issued by to Iman dated Iman as the counter is hereby withdrawn. So it has been withdrawn with effect from 1/4/2024.
Lordship, yes.
Then when were you
I have
appointed
requested-
thereafter?
I have requested on page number 42, Lordship, may kindly.
Now, when were you then again appointed?
Lordship, that is page number 42, Lordship.
This is written by whom?
This is written by me only as a proprietor.
No, when were you again appointed?
I have appointed somebody.
You have appointed, but your appointment was revoked. Here, see, the acceptance letter to so and so as accountable manager in LEP is hereby withdrawn with immediate effect.
Lordship, yes.
Now the question is, you have now again appointed yourself.
Yes, Lordship, that is page number
And
40.
this is not being taken into account.
Lordship, they did not, but finally when I approached the honorable court and they come to know and immediately they have accepted again.
Well,
that is page number 50 and that is 24/7/2025, Lordship.
Okay, 24/7.
24/7, that is
May
page
kindly
number
be
50,
made to
Lordship.
the letter on the subject and discussed with the DG, the acceptance of Iman is being considered and accepted by this court. Advise that an amendment of the maintenance may be suggested to it. Okay, then 24/7, then what happened?
Then Lordship, the main is like the previous accountable manager to whom I have appointed, he has done lot of illegality. And that is why I have sent lot of letter to government of India, that is DGCA, and DGCA officials are involved. And students' classes were not going on, regular classes were not going on, and they have shifted without approval of DGCA. The students were transferred to Odisha. And their regular classes were not going on. That is why I have informed the DGCA headquarters that the local officer, that is director, he is doing all this illegality. And I have complained to their complaining authority through proper channel. And that is pending. But again, these people, I don't know how it is. The DGCA again gave me a letter, that is email they have sent me, that is page number 54, Lordship, asking certain clarification regarding my ownership, regarding the as per CA or whatever requirement.
And then what happened?
Then, Lordship, I have immediately replied to them within
And
2 days itself. And then, Lordship, yesterday I have come to know evening that they have changed the accountable manager. They have again, that is illegally. So they have again accepted the previous person to whom he was my employee. So my employee has been again accepted by the DGCA. It is a nexus, Lordship. It is purely an illegality. And that is why I communicated with them. They are hiding all the communication.
Mr. Petitioner in person,
Lordship.
you withdraw the petition and file a petition when they do it.
Lordship, it will be too late, Lordship. Then
You have to challenge that, na?
they will not give me any that I got.
No, understood. But the question is, you have to challenge it. As of now, you have only heard.
Lots.
Let them do it. Then you come before this court. I give you the liberty for that. But the question is, now how do I take it? On what you have heard? This is hearsay, Mr. Counsel. So therefore, the question is, you withdraw it and thereupon you file. I give you the liberty to file it when there is any accountable manager being changed.
They do not disclose any paper to me. In fact, Lordship, if they disclose
this particular institute, you are the owner.
Lordship.
You are the accountable manager which you have appointed yourself.
Lordship, yes.
This has been accepted by these authorities.
Lordship.
After this, they have asked for certain documents from you.
Lordship.
After accepting the documents, now you apprehend that they are going to change you and give it to somebody else.
Lord.
That is what you are saying. But this apprehension is based on what?
Lordship.
Because of the letter, email they have written to you at page 54.
Lordship, page 54, yes.
That
Page
is the
54
apprehension.
No, not Lordship. If they hide their directions and their decision, then Lordship.
But the question is, unless you are being informed that you are not the accountable manager, you continue to remain as accountable manager.
Lordship, yes.
So they have to inform you. You cannot today say that, look here, you is not, let us not, somebody else will come in. That doesn't happen. They have to inform.
Lordship, that previously, the page number 37, when I appointed somebody else as accountable manager, that information, and he has been accepted by DGCA, that letter also not marked to me. That information also did not came to me.
This is being given to another person.
Another person. This communication also not given to me. Not given to me. No copy to me, Lordship.
No,
So
it has not been given to you, but it has been given to your college, which you are the owner.
Lordship, but college also, in my college also, they have
Is
not
that
sent.
person, Mr. Panda, he's sitting in your college?
I have given them room.
Now also?
No, earlier.
So now also what will happen?
But now he is not there. He shifted student
Orissa.
document also.
He has shifted to Orissa.
Lordship, yes.
So therefore they will appoint somebody, but they will appoint somebody there.
They cannot, Lordship.
Understood. So if they do it, they have to inform somebody. They have to inform you that you are no longer the accountable manager.
That is the main pathetic part, Lordship. If you kindly come to My communication to DGCA,
Okay, we'll do one thing.
Lordship.
Let this matter come up Friday. You take the what? Mr. K. Gogoi, who appears on behalf of the CGSC, submits that as the matter is being taken up as unlisted, he has not gone through the materials, and as such, he has not gone to the petition and requests some time. List the matter again on Friday. We'll see what happens. It will be right good.
My lord, in this case, I did not file the Okalafnama, my lord, but I will file, my lord, on next statement.
Huh?
The case is that, my lord, in respect of item number 55, my lord, the work is almost, my lord, completed. So it might become the infractions, my lord. I want to argue first item number 56, my lord. Because there is an interim order against the respondent number 6, my lord.
Item number
56.
So 651, you have nothing.
Yeah, nothing, my lord, because work has already been completed. As per his instruction, my lord, work has been completed. my lord.
Mr. NNB Chaudhary, the learned counsel appearing on behalf of the petitioner, submits that the petition has become infructuous. Taking into account the above, the petition stands closed as it has become infructuous. Interim orders, if any, stands vacant.
My lord, insofar relating to this case is concerned, my lord.
56.
Yes, my lord, 56, my lord. So for this case is concerned, my lord, what happened in the instant case, my lord? A tender has been floated, my lord. And there are two bid system. One is the technical bid, another is the price bid, my lord. I qualified the technical bid along with other three bidders, my lord. And my lord, price bid has been opened, my lord. I was found as a lowest bidder, my lord. And as a lowest bidder, I am my lord, expecting the work has been allotted to me, my lord. But there is a condition of the tender, they can split the tender, my lord. If there is a, my lord, some excess load of work, if is me, my lord. But at that time, there is no excess load in this work, my lord. Anyway, my lord,
But
there
have you done your part?
my humble review, there is a status quo order has been passed in this case, my lord.
Status quo has been mentioned out there. There is a modification to the status quo order that the person can go ahead and do the work.
I am coming, my lord.
Status quo order has been passed by the vacating, the modification is by, I think it is being done to the.
Yes, my lord, there is a status quo order has been passed, my lord. That is my instruction by my client, my lord. When there is a status quo order, we are obeying the order of the court, my lord. First, they also close all the work, my lord. Subsequently, they have issued an order on 26/5/2025, which has been bring through an additional affidavit. They give their, my lord, my lord, my lord, give their, my lord, reason that status quo order, my lord, I'm reading that, my lord, page 346.
When, what is the date of the year?
This is 26 February 2025. 332, my lord, affidavit started. I am reading 346. Reference is invited. This was
page
346, annexary.
No, 340.
Yes, my lord. It was not given to me. It was given to the other contractor, my lord, Rivera's Enterprise. Reference invited previous order, so and so dated, wherein you are directed not to start their work.
Where do I get it? In the to the
Page 346, my lord. Additional affidavit filed by my lord. Ask my lord.
You have filed it.
Yes.
Yeah.
It was started from 332, my lord.
Huh?
332 it was started. It was filed 18 March 2025. In a file was a file back. Evaluate got it. Page 332.
19 March 2000.
Yes, my lord.
By the petitioner.
Yes, my
Okay,
lord.
where?
Your lordship, kindly come to the annexer is E phase 346. Lordship, kindly, it was given to the respondent number 6, Rivras Enterprise. Respondent number 7, my lord. Sorry, my lord. Yes, my lord. Supersession of previous order regarding maintenance of status quo in compliance of High Court order dated 7/2/2025. So the reference to previous order dated wherein you are directed not to start work related to installation of 2-point solar power MDTW scheme on Ulor and 1 point at Durum under Dimoria LSC under RIDF NABARD for the year 2024-2025 under dispute division. Irrigation in the light of order issued by Honorable High Court in petition number so and so. Upon further review, legal consultation standing counsel, it has been observed that status quo is directly honorable required only to maintain existing state of affair as it was done passing of the said order. The previous directive not to start work is under misinterpreted honorable court order dated by the undersigned. Accordingly, earlier of the vice president.
Mr. Counsel, you were to complete the work within 60 days.
Yes, my lord.
Why haven't you done the work?
My lord, they are not, because they are just status quo order, my lord. Because this letter has been given to them, my lord. They should give to us also, my lord.
No.
And
Why should it be given? You have assumed by yourself.
and another thing is my instruction from my instruction, my lord. They are go to the give the additional performance security.
This is the work of you have to do within 60 days. You have not done it.
Additional performance security was not taken.
You are agreed. You have stayed the entire. You wanted the stay of the entire project. This is not done. These are public works.
My submission before your lordship is there. I am ready
I'm
to
not
do the
going
work.
to do that.
I am ready to do the work. Only
You have not done the work. You take action against him.
My lord.
Mister, who is there for a respondent?
Yes.
Take action against him.
Lordship, in the bid condition, a specific instruction was there. You have to deposit within 15 days, the performance security, Lordship.
He has not done.
Till date, Lordship, he has not deposited.
Deposit time are not taken by them.
Going to will not do, Lordship. It was in 15 days.
My humble submission before your lordship.
Where is your document that you have made the bid security?
My lord.
Where is your document? You cannot.
My additional affidavit stated.
No, not stated. Where is your document? You must have made something. How do you submit? You submit it by way of a bank guarantee or by way of a demand for how do you submit that?
We approach before the authority, my lord.
No, Mr. Chaudhary, how do you submit the bid security? You submit by way of a demand draft or by way of a bank statement, something to that effect. You cannot make a statement that I went out there. You are not going to pay him by cash. Where is your document to show that you have done it?
My lord,
no case.
My lord, only 1 day time may be given, my lord.
Time? 10,000 rupees cost.
My lord, only thing is that my name is not there, my lord.
Not
if you
there?
give the cost, my
Why
lord.
have you appeared?
That is that.
No. This court has clearly
My
observed
lord,
nothing.
1 week time may be there, so that I can file the affidavit.
Okay, tell you. 1 week time is 70,000 into 7.
My lord,
one day is 10,000. 7 days is
It's
7,000.
not there. Otherwise, he's
Upon you as a deterrent. Today, just now I have imposed 10,000 upon an council as a deterrent. You are a deterrent. Do the argument and finish it off. You cannot, for a 60-day contract, you are continuing for such a long time.
And others have already completed, Lord.
They have completed.
Others have completed.
No, my lord. Respondent number 6 has not been completed.
Others have completed, Lordship. One person has been barred by dishonor. I mean, stay order is there in respect of one, but he has also deposited his. He has also deposited his performance guarantee.
I am ready to do this work, my lord.
You have not submitted the performance guarantee.
My lord.
Nothing doing.
My lord, it was asked on 24/1, he was asked to deposit, my lord, and he was asked to deposit on 24/1/25, my lord. He filed petition 5/2/25, my lord.
Then period is over.
Page 288.
24, 1,
My lord.
25.
It was not given on 24/1 as per my instruction, my lord.
Everything your instruction, you don't know many things and don't say all this.
Annex 2, page
288.
Page 288 of his date petition.
Yes, sir.
Cost of 80,000, I think good.
My lord, your lordship, kindly allow me to go through this.
80,000. We are requested to submit the performance security deposit in the form of DD, FD, BG,
My
etc.
lord,
amounting
your
to
lordship.
rupees so and so only, which is 5% of the bid of the security of Iman only, and separately in favor of the security of Iman. Now, show me where have you made this DD, FD, BG?
My lord,
You are making a statement. Show me. When did you go to deposit? Tell me. And they have not let us take it.
I filed an
And
affidavit.
otherwise, I will initiate 340 proceedings or now whatever maybe, whatever proceedings are there. Show me where you have mentioned in your affidavit that you went out there.
395, my lord. Affidavit. Yes, come on. Para 4. 398, please.
Which affidavit?
395, additional.
Which affidavit?
It was filed on my lord. My lord, 398 page number. On August 2025.
August?
2025.
Then we don't have an affidavit.
That affidavit para 4, my lord.
You have submitted when?
It was submitted.
Show me that copy.
Yes.
You have it. You have a copy?
Yes.
One copy was
Give it to your man.
5858.
When did you went to submit the performance guarantee?
Yes, my lord. May I read, my lord?
Yeah. Yes.
Para 4. That the deponent beg to state that as per instruction of this honorable court as given on the last date of hearing, which was 28/7/2025, the deponent petitioner went to the office of chief engineer minor irrigation Sanmari in order to deposit the performance security to thereafter start their portion of allotted work, which is renovation branch.
As
Canal
per
to-
instruction of this court, when did this court instruct you? Show me.
What is
this statement? So,
Jungle
I
Moje
have
Bari?
been taking up this matter. I don't remember passing such instructions. Instruction?
The
It's
deponent.
not written in.
The matter having been heard at length lists the matter again on 6/8 at 2 p.m. That is the order. Where is the instruction by this court? Tell me.
The deponent went to
This
the.
is a false affidavit. And first of all, I never said anything to the effect. This
My lord,
court
one
never
thing
said
that, my
anything.
lord,
And
Excellent,
the
my lord.
instruction,
Actually, my lord, in this matter, my lord, as both today some difficulty, my lord.
who?
As both. That is why I was, my lord, stopgap arrangement to do this.
So you stop the and argue then.
I
Don't make false statements before
and
this.
only your lordship make 1 day time, my lord, 1 day, tomorrow, my lord.
Okay, 10,000 rupees cost.
But only on 1 day, my lord.
So that is 10,000. 7 days, I give you 1 month, 3 lakhs. Which one do you want? Argue.
Only 1 day, my lord. 1 day, my lord.
Who is respondent number 6? Kamrup Enterprise.
Lordship, it's the other party, Lordship, who has been, among which the Lordship work was split between him.
Has he completed?
He has completed, Lord.
Now, why there is an order passed by this court on 10/4/2025?
That is in
An
the other
affidavit
case.
has been filed showing the status of the execution of the work by the respondent number 7,
Yes.
which goes to show the respondent has not started any work.
No. Respondent number 7.
In view of the opposite till the next date, it is provided that no work shall be allowed to be started by the respondent number 7.
Yes, he was by a subsequent order, Lordship, he has also been barred to continue with the work, Lord.
Where?
One order probably is there, Lord.
In IA. IA says,
My lord, order dated 10/4/2025.
10/4, I have read it.
Yes.
Thereafter,
10/4, 8 case, no, 8 case.
Rahul is coming.
Respondent number 7 has been.
Revraj is completed. You have completed. This IA is for release of the earnest money. You ask them, why should this court say? Now, where it means respond number 6 have not been allowed. Who is appearing for respond number 6? The heard Mr. NNB Chaudhary, the learned counsel appearing on behalf of the petitioner. Mr. P. Nayak appears on behalf of the respondent numbers.
I'm appearing for state response.
Respondent numbers 1 to 4.
1 to 4.
Full stop. Who appears for 5? Appears for respond number 5. 6. 7. Mr. J. Gore appears for the respond number 7. Full stop. The petitioner herein has approached this court, challenging the work order issued in favor of the respondent numbers 5, 6, and 7, thereby splitting the package number 38 which relates to a contract for renovation of branch canal 2 from Cheney's point 0-173M at Quazari QUZARI Roman 2 PC, renovation of branch canal 2 from Cheney's dot 0-200 meters at Jungle Malloy Bari IPC, capital Roman 1 PC. In respect of bracket package 38 part, in respect of renovation of canal system at different pump centers of Maloibari ELIS under RIDF-XXX NABARD for the year 2024-25. The grievance of the petitioner herein is that the petitioner, though was the lowest bidder, but the respondents have splitted the work in respect to package number 38 amongst the petitioner and the respondent numbers 5, 6, and 7, isn't it? Mr. Nayak, his grievance is that being the lowest bidder, the respondent, the authorities have split the work among pertaining to package 38 in amongst the petitioner and the respondent numbers 5, 6, and 7.
Yes, well, this prayer was the he being the lowest bidder.
Understood.
Yes,
That is his grievance.
That is the, I was given 22 lakhs, he was given 60 lakhs.
Per contra, it is the stand of the respondents, authorities, that in terms with clause number, where is that? Clause number
29 3.
29.
Page 59.
Page
59. Yes, my lord, page 59, 29 3.
In terms with clause 29,
3.
is Roman 3. The employer reserves the right to split any package to allot the work amongst other successful bidders of the package at the lowest accepted rate of the package without intimating the L1 bidder. And accordingly, the respondent authorities have split the contract pertaining to package number 38 amongst the petitioner as well as the respondent numbers 5, 6, and 7. Mr. P. Nayak further submits that in the meantime, the respondent number 5, you have completed? Have you completed or not? The respondent number 5, 6 has completed, Mr. Nayak?
6 Lordship has not. 6, yes.
7?
5 and 7 complete.
5 and 7 have already completed their work in question. Have already completed their contractual work. However, the respondent number 6 have not yet completed in view of certain interim orders being passed by this court. It has been further submitted that the petitioner, where is the document by which performance guarantee was given?
But if he was asked to deposit within 7 days.
Where is the document?
That is last page of the petition, not 280. So in respect of petitioner, this is 285. 285.
The learned counsel for the respondent authorities further submitted that on 24/1/2025, the petitioner was directed to deposit the performance security deposit in the form of DD/FD/BG, etc., amounting to rupees 1,37,900. An additional performance security of rupees 2,55,900 within 7 days from the issue of this letter of acceptance. However, the said amount have not been deposited. And on this ground alone, the petitioner cannot have any right in respect to the right or claim in respect to the contract in question. The learned counsel for the respondents further submitted that a perusal of the document would show that the work in question pertaining to package number 38 was required to be completed within a period of 6 months. It has been submitted that on account of the petitioner not depositing the performance security as well as the additional security and entering into the agreement, which was mandatorily required, and therefore on obtaining a status quo order, the said work have not been completed, which is not only affecting, not only delaying the execution of the project contract, but also against public interest. This court further takes note of that recently. On, when did you file this affidavit?
I was filed on affidavit, my lord, on August, my lord.
You don't know the date.
5th of August.
On 5th of August 2025, this court further takes note of. Now, this court inquired with Mr. NNB Chaudhary, the learned counsel appearing on behalf of the petitioner, as to whether the performance guarantee, as to whether the performance security deposit as well as the additional performance security have been deposited by the petitioner in pursuance to the communication dated 24/1/2025. The learned counsel submitted that an attempt was made to deposit pursuant to orders passed by this court on 28/7/2025. This court further inquired as to why the said amount was not deposited. Pursuant to the order dated 24/1/2025, it was submitted that the said amount was not deposited as there was a status quo order passed by this court. This court further finds it pertinent to observe that in terms with the communication dated 24/1/2025, the petitioner was required to deposit the performance security deposit as well as the additional performance security within 7 days from the issue of the letter of acceptance, meaning thereby on or before 1st of February 2025. In the instant case, the status quo order was only passed on 7/2/2025. Under such circumstances, the submission so made by the learned counsel appearing on behalf of the petitioner appears to be is misconceived. Next. This court further is of the opinion that on account of certain interim orders, the respondent number 6 is not in a position to carry out the work. The work is necessary to be carried out in public interest. And on account of a stay at the behest of a petitioner who has not even complied in terms with the letter of acceptance, it would not be in the interest of justice to continue any interim orders, thereby stalling the completion of the work. Accordingly, this court vacates all interim orders, any interim order passed in the instant proceedings, and directs the respondent numbers 1 to 4 to duly inform the respondent number 6 to complete the work in respect to the contract, in respect to the contract of the work so awarded. This court further directs the respondent authorities to further proceed as the counsel appearing on behalf of the petitioner seeks for further accommodation. List this matter when 1 year, 2 years.
As your lordship like.
On 8th of September 2025. Huh? What payments? Huh? You are the petitioner?
No.
So you come to that side and file a petition?
I only, so far as respondent number 6 is something your lordship has verified. But the work that has been allocated to the petitioner.
Didn't they say all interim orders are vacated?
I can still know in report.
Status quo? everything goes for a 6. Now you know what to do.
Can I deposit secret?
No. It is a false statement you have made. And that this court had instructed you. My goodness.
Daily list item 10 for admission.
But you informed the respondent number 6 to carry out the work.
Today on 1 PM, my lord, they file your affidavit in opposition. I want to file reply.
Huh? Affidavit filed?
Yes. File.
Okay. Affidavit is being filed. What do they say?
They says that I am working on for orally, my lord. I am doing everything, but they says that my lord approve for allotted to the contractor. But
Work order issued?
no work order was not.
Oh, telephone instruction.
I am actually innovation of the renovation of the electricity, my lord. Only 397 rupees.
Okay, what do you want?
3 lakh. My lord,
Time to file affidavit or dismissal, which one?
at least
Reply.
reply. Because of that, the representation also they
For
say
which time granted to the petitioner to file reply to the affidavit in opposition filed by the respondents.
March.
11.
What is this?
Please, Lord. Lordship,
Case about?
this is for release of the earnest money, SD1 and performance guarantee.
Release of the earnest money.
Earnest money,
Have they filed the affidavits?
yes, Lordship.
Now what do they say?
Lordship, but we have implemented new respondent number 5, 6, and 7 has been newly implemented.
Huh.
So the reply needs to be filed actually.
So why do you need to perform BG?
Lordship,
BG has not been invoked. Has it been invoked?
yes, invoke.
Huh?
Invoke, Lordship. They have forfeited.
Why?
Lordship, may kindly have a look at page number.
Who has
What?
done this problem?
Deputy Commissioner, Lordship.
Huh?
Deputy Commissioner, he has issued an order.
Who is appearing for the deputy commissioner?
11.
What are you challenging? Construction of man determine the contract that the man. So this is the order of page 69. You are challenging this order.
Yes, Lordship. Page number 43, Lordship.
No, you are challenging order at page 69.
Yes, Lordship.
So it has been terminated.
Lordship terminated.
Then why you are not proceeding before the civil court? Why is this court being invoked? Huh? The counsel appearing on behalf of the respondents, Mr. M. Setia, do not have the brief. Good stuff. The counsel, none appears on behalf of the central government also. Considering the above, the matter stands adjourned to be listed again on 5th of September 2025.
Our name may be reflected.
You go there, you know what to do.
Well,
The names of the council appearing on behalf of the CGSC as well as GSM be reflected in the cause list. What is this?
This is a multiple property society, my lord. They are supplying the labor, my lord, from the society.
Huh?
They are supplying the labor for the society, my lord. So once, my lord, a work order has been issued, you will also find at page 21, my lord. This is for a period of 2 months, my lord, for supply of the labor.
Yes.
Then, my lord, yes, then it complete, then.
What work did you do?
Well, they, laborers, my lord. Parcel, parcel, they laborers, they supply, the laborers, my lord.
What supply?
Rolling of the parcels, my lord, for labor, my lord. For
Labors for?
labor, for the parcels, my lord.
Parcels.
Now, what happened, my lord, after
You are what? A society?
Mazdoor society, my lord.
So
Mazdoor
these
society.
are all individual persons.
Yeah, they are individual persons, we are, my lord, supplying them, my lord.
Who is supplying? You are supplying.
Yes, society.
Society is supplying. And you supply only on verbal orders.
My lord. Verbal orders, my lord, the first work order was given. Then, my lord, tender for 2 years was issued. In the meantime, my lord, the tender settlement was taking time. So they asked that whether you are agreeable to do the work at the same rate. We issued a letter.
Did they ask verbally?
Verbally.
And you also said verbally?
No, we have issued a letter.
Where?
Page 26.
Page?
Page 26.
The above work was allotted to us for a period of remand. The said period of remand will end on remand. The tender for the work for a period of 2 years has already been put. However, we are agreeable to work at the existing. This is your volition. You are submitting that we want to do.
Then, my lord, we supplied the laborers, we submitted bills and they verified it and they have accepted it.
Where?
My lord, these are bills from 27 onwards.
No, where they have accepted it?
My lord, no, they verified, my lord. It is.
Huh?
They have verified.
Verified is what?
Yes.
This is to certify
They
the
also
handling
submitted, my lord,
contractor
they have,
daily for only
they have issued letters, my lord,
It is
that
further certified that no demerit charge accrued against the handling contractor at so and so.
Yes.
You are a contractor.
no, yes, my lord, page
You are a
29.
contractor. Go there
No,
before the
page-
civil court.
No, page 29, your lordship see, my lord.
No.
No, page 29, your lordship see.
What is there?
And these all certificates are given, my lord. Every day we are supplying the laborers, my lord.
What?
52 laborers, my lord. This is the certificate by the, my lord.
What period?
My lord,
During the month of April.
April. Similarly, my lord, for all months, my lord, it is given.
So?
So,
Who there?
no,
These are proof.
Now, later on, my lord, the work has been allotted to us, my lord.
Huh?
What later the work was allotted to us, my lord. Then
Fantastic. Why did you why on earth did you do all this work?
my lord, that is, my lord, section 70, my lord. That is what I am
What
submitting, my lord.
section 70? No section 70. Section 70 go for a civil court to apply. Not
My lord,
this is the matter. The pleadings are complete. When do you want the dismissal if I am in my hands? When? Not a good day time. After puja, before puja, which one?
any day, my lord, I am not. No.
You try your luck on 5th of September before another court. This is the matter on 5th of September on which date an attempt shall be made to dispose of the petition.
13.
Who appears? Any information? None has appeared on behalf of the petitioner. It is seen that on the earlier occasions also none has appeared on behalf of the petitioner. It seems that the petitioner is no longer interested in the proceedings for which the petitions were dismissed for non-prosecution.
Item 14.
May I please the lordship? The amount, we have received the amount, only the security money is remaining to be paid.
What?
We have received the amount,
How much?
30 lakhs,
And you want another 16 lakh?
80, no, sorry, 8
8.
8 lakhs.
But why did you ask for 46 lakhs when you filed the petition?
There was 30 lakhs, 80,000.
Ah.
The 80, I think they have already paid 30 lakhs, 80,000. And then now it's remaining 8 lakhs.
Any 8 lakhs are remaining.
Yes.
The counsel appearing on behalf of the petitioner submits that out of the total amount claimed by the petitioner in the present proceeding. Now, out of you are asking for 46 lakhs.
Yes.
Why you are saying 30 lakhs, 38 lakhs?
38 lakhs, they have to give the payment for the work and 8 lakhs for security.
8 lakhs for security. Now 8 lakhs you have received. No.
No. We have received 38. Yes.
38 you have received.
Yes.
38.
Yes.
The counsel appearing on behalf of the petitioner submits that out of the 46 lakhs which the petitioner has claimed as outstanding dues, 38 lakhs have already been received by the petitioner. However, the 8 lakhs amount which is the security deposit have not yet been released. Ms. R.B. Bora, appearing on behalf of the respondent counsel, shall obtain instructions and place as to whether the petitioner is entitled to any further amount. List this matter on 22nd of September 2025.
Item 15 and 16.
Yes, what are these?
May I please your lordship? Lordship, actually the matters have come by order because we had made a mention for the listing of the matters as they were off listed. However, lordship, now due to some personal difficulties, we are withdrawing as the counsel from this matter and we have already informed the petitioners, so they will be taking the brief from us today itself.
What is the case, Mr. Chakraborty?
Payment of amount they are claiming.
Huh?
Payment of amount which you have disputed.
Okay. The counsel appearing on behalf of the petitioner, Miss.
B. Saika on behalf of H.K. Das.
Counsel appearing on behalf of the petitioner submits that the file has already been taken from them and they are no longer engaged. Mr. B. Chakraborty appearing on behalf of the railways, submits that the claims are disputed in nature, and as such, this court may not exercise the jurisdiction under Article 2 to 6 of the Constitution. Taking into account that the files have been taken from the counsel for the petitioner, this court fixes the matter again on 15th of September 2025. In the meantime, the counsel who today has appeared before this court shall inform the petitioner by way of a communication that the instant proceedings are fixed on 15th of September 2025.
You oblige your lordship.
17.
And the same communication be also filed before the registry of this court.
Right, Bishop.
What is this?
This is a non-payment of contractual bill, my lord.
Complete instruction. Yes,
What? 2024.
23, man.
23. Hello? This is has anything to do with central government?
No.
No.
Your lord.
Okay.
No.
Verify. Payable 6 months. Disposable.
18.
Please, your lordship.
My lord, license has been cancelled. Is there cancellation, my lord? Please.
Prior to the that license or visa was suspended by condition notice and so. What is that? License cancelled?
Yes.
Then why you're not filing affidavit? Mr. K. Gogoi, what is wrong? You were the person who has accepted the notice. You don't take the responsibility.
Letter was communicated.
You have taken the range of alternative remedy of appeal. Why you are not filing appeal, Mr. Counsel? Mr. Counsel, why you are not filing appeal?
My engaged senior counsel left for personal inconvenience.
So that is why you have not filed appeal.
No. So sir tell me, a respondent has not filed the affidavit.
They have taken away dangerous ground on the maintainability. Why should we look into it? Anyways, the counsel appearing on behalf of the respondents have not filed the affidavit in spite of notice being issued in the year 2000, in the month of February 2024. A final opportunity is granted to the respondents to bring on record their stand by filing the affidavit. So list the matter on 24th of October 2025. Gustav, the affidavit be filed by 16th of October 2025.
Nice.
19,
Saha.
In this case, my lord,
On account of
I,
Oh, have you filed that affidavit, Mr. Dinath?
yes, they have filed affidavit. I want to file rejoinder affidavit, my lord.
Why?
Because my lord, they have taken U-turn, my lord. Because in my, your lordship kindly see in my work order, they quoted the rate. Now they are not going to that rate, my lord. So I want to file my affidavit in details, my lord.
Well, we have it in the month of July next year.
No, my lord. After 1 week, my lord.
Then we can have, there will be election, 45 days, they will then file election petition, and I hope I will get an election petition out there, and then we'll have a witness box. These disputed questions I will decide.
No. In your lordship kindly see in work order, e-tender notice.
The
was I
DGM
quoted.
Montal Senior Counsel submits that in view of the affidavit filed by the respondent on 4/8/2025, the petitioner would like to file their reply. List this matter on 3rd of November 2025. In the meantime, the reply be filed.
item 20,
Not November, my lord. No. In September last part, my lord.
No time. Vacations are in here.
Then say,
You see my calendar out here.
my lord, I know, my lord. That's
Then I cannot do it.
next one, my lord, same, my lord.
Same. See, people are filing affidavits when I'm thinking of this.
Deep level.
Yes, Mr. Bhatti. No matter.
23.
Something must be very serious, huh?
My lord, they filed the affidavit on 30th July, and I like to file the reply, my lord. So 1 week time I can leave.
Okay, the affidavit has been filed by the respondent numbers 1, 2, and 3 on 31/7/2025. First up, the counsel appearing on behalf of the petitioner, Mr. O.P. Bhatti, submits that the petitioner would like to file a reply. List this matter on 10th of November 2025. The reply be filed accordingly.
24.
Affidavit filed. Mr. Gogoi.
David, pilot, I have sent it for rating.
Oh, then not
I can
necessary.
file it, pilot, other than instruction is very clear, it will be in Dharampur only. Very clear. It will be in Dharampur.
It would be non-payment.
Well, that we have filed, madam. Sorry, madam, that's the wrong instruction. No, we have filed the affidavit.
You have filed affidavit. Now, what is your stand?
Madam, there is a notification issued by.
Don't go ahead. Now, he is asking for some money.
Yes,
whether he is entitled or not.
Madam, this says, madam, it could not be released due to non-payment. Same could not be made due to non-receipt of administrative approval. Here, madam, that approval will have to be granted by the, madam, revenue department. I have finally appearing. We are the executing authority. They are the one who will finance.
But they are party, na?
They are party.
You have verified he is entitled to.
Yes, otherwise, my lord, we have stated because of the administrative approval, we have not been able to make the payment.
No, but the fact that he has worked and is entitled to 81,63,000 is being verified or not?
Right, the affidavit says so, my lord, that it has been verified because of paucity of fund.
That's a different thing.
Yes.
But I am asking you whether you have verified whether petitioner is entitled to 81,63,000.
Yes, my lord, it has been stated.
None.
Yes.
So this is as per the, this will go as per Taksem only, come say.
And it's the work of the revenue department.
Then it,
executed by the PWD for their part.
that's I think they,
We are file. Affidavit already has been filed.
you are, then you have,
Application out to be filed. In the amount of that, Lordship may kindly go to my additional.
no, whether you agree to the amount.
All of that, in the meeting, Lordship, state executive committee. All of that, it is given, all of that, 52.6, the PWD in some all of that, chairman, agenda of the payment.
Work is yours.
Work is done by the PWD.
They may do.
The technical department.
Today, the High Court may give many work. All works are done by the PWD. But the fund will be given by the Judicial Department to the High Court and High Court will defray. Isn't it, Mr. Gugoi? Isn't it how? You also know, I also know. But it is only just 6 months.
No.
Disposed. Positive fund Mr. B. Gogoi, the learned counsel appearing on behalf of the PWD, submits that as per the work order, the petitioner have duly completed the work, and upon verification, it has been found that the petitioner is entitled to the amount so claimed of rupees 81,63,000. However, on account of paucity of fund and the administrative approval not being obtained by the revenue department, the said payment could not be meted out to the petitioner. I prefer to lay that when the petitioner has carried out the work, he is entitled to Hiputasana 6 months. From the date a certified copy is there to the home to Commissioner and Secretary, Revenue.
Yeah. Commissioner secretary. The commissioner secretary, which is not there, that additional. Chief secretary.
Additional Chief Secretary, which department?
Revenue and.
Who is the department? You have made him a party?
Yes. No, commissioner secretary is the.
Commissioner secretary party.
So yeah, to the Commissioner and Secretary, we
Commissioner secretary.
copy because he's a party, na? Because tomorrow again somebody will say he's not a party.
Obliged.
Respondent number 2.
Two. Yes.
25.
Ola Shah. What is this matter? Why is the petitioner not preparing? AC to salary of more gorom which is. Yes. You are entitled to pay money.
Yes, my lord.
Huh?
The amount has been paid, my lord.
How much?
The amount. 7 lakh. 7 lakh. 7,000.
How much he is entitled to as per your instructions?
Yes. We have filed it.
How much?
He is now under 3,75,100. Take a 4 hour.
Date?
63.
So 7 lakhs have been paid.
Lordship.
And only remaining is 3,75,130. Mr. Counsel, you are only entitled to that amount.
Sorry for being late.
No, I'm asking you, you are only entitled to 3,72,5,132 as per them.
That has been received.
That
7
was
lakhs,
received.
7 lakhs. That amount is received.
What are you entitled now?
Now, Lordship, may kindly go through this.
You claimed how much? 11,53,000.
Yes, Lordship.
Of which?
Of which 7 lakhs, 7162, 707162 has been received.
Remaining is 4,46,766.
Then,
Then
so
Lordship.
you don't agree to this 20%?
Yes, Lordship. Actually, 3 years have elapsed. And they did not pay in the year 2022, neither in the year 23. So,
Mr. Council, we can do two things.
Lordship,
We accept your one-time settlement not being done. But we relegate you to the civil court. And what will happen to the limitation then?
Lordship.
Whatever you have got, I think you should be happy with it.
Lordship, I am happy.
I think we should close it. You have received it 375 to 132.
Lordship.
The learned counsel appearing on behalf of the petitioner submits that though the petitioner had claimed an amount of rupees 11,53,928, but the petitioner have already received an amount of rupees 7,07,162 as well as rupees 3,75,132 during the pendency of the instant proceeding. Full stop. Taking into account the above, the petitioner further would not like to press the instant petition, and accordingly, the petition stands closed. M. Setia appears on behalf of the police administration.
26.
Lordship.
Uttam Saha, yes,
My
what
lord,
is this?
this is my lord, been set for waiting, my lord. I have 3 working days I am trying for it.
Mr. S. Dutta, appearing on behalf of the PNRD, submits that within 3 working days, the affidavit in opposition would be filed. Taking into account the above, list this matter on 29th of August 2025. The affidavit be filed positively by 22nd of August 2025. Liberty given to the petitioner to file any reply
Item 27.
on or before the next day.
Sorry, Lordship, in the previous item, we owe another 3 lakh something. So can I get a order so that within so and so period, that amount may be released by the authority
Which
after
amount?
deducting 20%, 3 lakh something?
That is another amount,
Yes,
which is not the subject matter of the writ petition.
subject matter, Lordship.
No, there,
Yes, sir. Same subject matter.
Same subject matter.
Another amount of 7 lakhs already this matter, remaining is 3 lakh. Remaining is 3 lakh.
sorry, he has already received this amount, but his only claim was 11 lakhs.
Yes, out of the.
Out of that, 7 and 3 has been paid, which comes to 10.
No, 3 lakhs is not paid. 3,75,000 is not paid.
Yet to be
Yet to be
paid,
paid.
received.
So that is what I asked him, whether did you get the money?
That amount is not yet received, Lordship. Only 7 lakh something is.
আগৰ সেই কেছটোত কৈ দিব যে 7 lakhs to pay হৈছে এই তেওঁলোকৰ affidavit of 3,75,000 would be paid. Payment be made within a period of 6 months. সেইটোৱে আমি যোনটো order থাকে কিন্তু আগতে তেওঁ 11 lakhs খুজিছে and he has raised the issue of 20%, nothing. He said, Iman, they have already entered into this. The affidavit of transfer কথাটো কোৱা আছে মানে amount দিয়া হৈছে আৰু কিমান 3,75,000 due shall be paid after due verification as to whether the said amount have been paid, and thereupon, if not paid within 6 months from the date a certified copy is served upon the DGP. Puruhura manong ni DGP.
27.
Tiwa.
Yes.
Who is appearing for Tiwa? Mr. NJ Khatonia, all cases of Tiwa is you with you. Huh? You are appearing for Tiwa?
I'm on behalf of SEU. I'm on behalf of SEU.
Where is he?
Yes, left the court due to some personal difficulties.
SP? S. Nugi. Okay. Taking into account that Mr. S. Nugi is not present before this court, we list this matter again on 8th of September. On that day, I'll pass the same order. You have those orders.
I have this with here, in fact, if Lordship wants to pass the similar order, can be passed.
I cannot do so when he is not there. Because tomorrow somebody will say, who is he?
Lordship.
Lordship.
28.
Okay, permit me, then item number 23. In the meeting, my lord, then the PWD, my lord, is the other part of some conflict within the department. Will direct both the departments verify who is due to pay, my lord. Pay accordingly. Instead of two, revenue and my lord, PWD will verify.
Line to it appears from the affidavit so filed by both the departments that there is a tussle amongst the department as to who would be liable to pay. Be that as it may, the fact that the petitioner had already completed the work and the petitioner is further entitled to, upon verification of an amount of rupees 81,63,000, the respondents, the tussle amongst the respondent departments have to be resolved amongst themselves, and the said cannot be a reason for depriving the petitioner of his legitimate dues. Accordingly, this court therefore disposes of the instant writ petition, directing the respondents herein, all the respondents herein, to take appropriate steps for the purpose of disbursement of the amount of rupees 81,63,000 after making such a statutory deduction if so required within a period of 6 months from the date a certified copy is served upon the chief engineer Juntu Asana Silago, who is there, as well as the respond number 2. Respond number 2, 2 and 3.
May I please, your lordship?
Item 28.
May I please, your lordship, due to bona fide mistake, lordship, I could not take the step, lordship.
What is this non-payment?
Here, lordship, ministry is a necessary practice.
Miss DJ in appearing on behalf of the
D. Devi, lordship.
D. Devi,
Lordship.
appearing on behalf of the petitioner, submits that taking into account that there is an involvement of the Ministry of Jal Shakti, an appropriate application would be filed for the purpose of including the Ministry of Jal Shakti. List the matter upon such application is filed.
29.
Yes, what is Amul doing?
My lord, our godown has been desealed, but my lord, the other side has given me a receipt that we have already paid an amount of 5 lakh rupees as penalty. My lord, I may be allowed some time to take instruction on this. Because this is the carrying and forwarding agent who has paid it, but the original Amul who is the one who has filed this writ petition. That's why.
Why did they? Because of no trade license. Oh, this is 404. 404.
No, my lord, we had trade license actually. There were
I know that. 404. You know this lawyer, Mr. S.J. Sharma. You know him? You must be knowing him. He also practices in the civil court. Ask him. I passed an order on this 404 business. That they cannot, one bandit come up, they look here, we need 5 lakhs. They are doing it at the AI instance that 5,000 is the minimum.
Yes, my lord,
That is the maximum per day. So they say whatever may be 5 lakhs tomorrow. I said out there that there has to be a notice. Notice followed by an order. After that, order is there.
My lord, there was just a notice of demand and they sealed it immediately. In fact, my lord, the CNF agent had licenses in his name, and even the original lesser had the license.
The counsel appearing on behalf of the petitioner submits that he has received an instructions today and he would like to file an additional affidavit.
Yes, my lord. No.
Bring that if you want to get refund. Or you don't want.
My lord, we want to.
At least the matter of the 4 weeks.
30.
Non-payment,
Is non-payment.
we agreed.
Admitted amount, my lord, some amount is disputed, my lord. Claim, my lord, 8,05,000. Admitted amount is 7,25,000. Therefore,
Dispose of কৰি দিব হা paragraph number
forward.
quote কৰি দিব এই পুলিচৰ যে আগতে এটা judgment এটা দিছিল নহয়, আপোনাৰ যে লিখিছিল না পুলিচৰ বহুত যে লিখিব লগা হৈছিল তো এনেকুৱা কম লিখিব paragraph 4 টো quote কৰি দিব হা আৰু সেইখিনি আছে to be এইটো সেই এনেকুৱা 6 months
31.
আৰু petitioner counsel টো নামটো যে আছে তাক ভৰাই দিব
Non-payment of bill. Respondent number 3 has filed.
first time
Lordship,
you have instructions or affidavit filed.
Lordship, respondent number 3 has filed their APTP. They have
Please.
admitted the amount.
What do they say?
They admitted the amount. Para 9, Lordship, page 3.
Para 9 to ito kupuri. 6 months.
Lordship.
32.
Non-payment of dues, your lordship. They have admitted the amount. They filed the affidavit in opposition. Paragraph 6 and 7 of the opposition are relevant.
Where's filed the affidavit?
The district agriculture officer. Dimasa.
Where do they admit?
At paragraph number 6.
They are saying that they are trying to. How much is the amount?
53,38,000.
Where do they admit that?
Paragraph 6, if I may read your.
That in 10 months will clear up.
Huh?
That admission is not here in the affidavit. But
Why this type of affidavit is being filed?
But in 10 months we'll clear it. We have till
Within?
10 months.
What is this 10 months business? Why did you take the work if you don't have the money? No, ask this person, the director of district agricultural officer, they won't do. Ask this director of EA to file an affidavit. What are this type of EA? Who files this? Not Kachara, principal secretary. Yes, number 3. He's
Number
the
3.
district agricultural officer.
Yes.
Okay. This court have duly taken note of the affidavit filed by the respondent number 3, wherein it has been duly mentioned that the petitioner had duly supplied the goods in full and in good condition, and and further, as per the specifications of the short quotation notice dated 26/7/2024. However, there is no mention, strangely, there is no mention as to what amount the petitioner is entitled to, inasmuch as the petitioner herein claims an amount of rupees
53,38,876.
53,38,876. Full stop. The Mr. C. Sharma, who appears on behalf of the respondent number 3, this court directs the respondent number 3 to file an affidavit in that regard by 5th of September 2025. List the matter again on 10th of September 2025.
33.
Mr. Sri Sharma, you didn't look into that. You should have been more clear. What type of affidavit you are filing?
I have asked, but they take
This is a very clever mode. I pass an order, then something happens. Don't put us in. Yes, what is this? Petitioner further cases, the amount claimed by the respondent against the petitioner is under adjudication before, and as such, the stand of the respondent that the recovery of the petitioner into the. Huh? None appears on behalf of the petitioner on call. Mr. S.S. Roy appears on behalf of the CJ, appears on behalf of the central government. List the matter for ends of justice matter sent to John to be listed after 4 weeks. In time order there, no, none.
34.
Here in this case, my lord, affidavit in opposition already filed by the district commissioner, my lord, and I want to file a reply, my lords.
Mr. T.
I allow. I allow. my lord.
I am. The learned counsel appearing on behalf of the petitioner submits that that he would like to file an affidavit in reply to the affidavit in opposition filed by respondent number 5. Full stop. List this matter again on 12th of November 2025. In the meantime, the affidavit in reply be filed.
35.
Yes, same.
No, my lord, same, but I have challenged the appellate order, my lord. Appellate order, my lord, against the suspension
Are
of
you
my
going to file affidavit? No.
district commissioner filed affidavit, my lord.
Are you going to file your reply?
It's not required, my lord, but state's response is required since the secretary Potency Civil Supply have rejected my appeal, my lord.
So why do you have to do this? When they are exercising judicial, quasi-judicial authority, the question does not arise. You have to ask them the reason.
My lord.
If the reasons are not apparent, then it goes.
Right.
Hello.
In
So what
that
to
case,
do?
both the matter may be
What is the interim order to continue? Mean? What is this interim order business?
no whatsoever.
You are running a fair price shop. It has been cancelled.
Suspended, my lord. Against the suspension order, I have challenged before this honorable.
There's no interim order there.
No, my lord.
Now, what is this interim order? You filed an appeal.
My lord.
Now, where is the question of meanwhile, till the next, no steps in respect of a petitioner's license be taken without leave of the court means? What interim order is this business?
Not to cancel, my lord, in fact, my lord, not to cancel.
Why? It has been suspended, it will be cancelled. Have you submitted this report? Have you cancelled or not? Cancel it.
In fact, my lord,
Immediately, that is there. We dismiss this one. What is there? The question does not arise.
since my lord, I have.
Have you submitted your reply?
Uh,
That case is for challenging the suspension.
My lord.
Now the suspension is going on.
My lord.
Now, in the meantime, the proceedings have also started. They have issued the show cause.
No, my lord, no show cause issued, my lord. No show cause issued, my lord. Since, my lord, against the suspension order, my lord, I have challenged it before this honorable court. And honorable court,
Matter this will have finished on 21st. List this matter on 21st August.
My lord.
We'll have it early.
37.
On 9th of September, we'll have it.
My lord.
Both matters. In the meantime, you file your reply in that matter. Both are same matter, na?
No, what are connected? No, my lord, in fact, connected, but appeal is different, my lord.
Appeal, it's okay.
In that case, your lordship may both the matter taken up.
এখনো তো আপনার 9th নকৰিব 16 September দিব এইটো এইটো list the matter on 16 September.
My lord.
Taking into account the scope, this court is not inclined to extend the interim order.
My lord. Item 37, my lord, I have.
You are doing it in a series.
3 matters, my lord.
Yes.
38.
37.
37?
37 different. Oh, sorry, my lord.
Okay, what is this?
Yes, sir. We have received inspection, my lord.
Non-payment?
No, normal, non-renewal of license, my lord.
Non-renewal of my license, my lord, gun license.
Subsequently, it was cancelled.
What license?
Gun license, my lord.
Drug license?
My lord. Within time, my lord, I have.
Gun license.
My lord.
Then what happened?
My lord,
Actually, it
within,
was cancelled, my lord, because he was involved in a criminal case.
no, my lord, that is not a committee.
Anyway, somebody has filed an affidavit on 23/7/2025. You want to file reply? No.
No, my lord, they will not, they have to file, my lord.
No,
They have-
somebody has filed affidavit in opposition by the Commissioner of Police.
No, my lord, we have not received any.
It is there, 23rd of July. I Imdad Ali. Are you Imdad Ali?
I am appearing for item number
I
37. my lord.
Imdad Ali so and so presently serving as the Deputy Commissioner of Police do hereby solemn and there you have given reasons why you have done.
Item 38, my lord.
No, this is bills.
Yes, my lord, it is bill, my lord.
Item
It is
38.
Huh?
37.
I am appearing for 37, my lord.
37 to be okay too. The other appeal was filed is where?
That is in respect of food and civil supply.
37 to be okay. That is where I'm. 37 is what? Rakesh Singh.
Regarding renewal of gun license, my lord.
You have been received the instructions?
Yes, my lord.
File your affidavit.
Yes.
The counsel appearing on behalf, Mr. M. Sethi appearing on behalf of the respondent submits that they have received the instructions. Taking into account the same, taking into account the above, the instruction, the contents of the instruction, this court is of the opinion that the same be brought on record by filing an affidavit so that the petitioner would be in a position to rebut to the same. Also, taking into account the above, list this matter on 17th of November 2025. In the meantime, the affidavit in opposition be filed by 3rd of November. Liberty given to the petitioner to file the reply. Yes, the other one, AB commercial.
May I please your lordship? Matter pertains to non-payment of contractual amount. And they have admitted lordship. And in their affidavit in opposition, lordship may kindly peruse page 23. Page 20, lordship, para 5. Next, vote and apply.
ওপৰখিনি আগৰখিনি লিখিব। The instant petition has been filed, 40,39,000 এইখিনি আগৰখিনিত আহি যাব ন। An affidavit in opposition has been filed by the respondent number 3. That is the Commissioner of Police, wherein it is stated that the petitioner is entitled to, after upon verification, the petitioner is entitled to an amount of rupees 9,44,587, 4,52,548, 11,74,267, 3,47,148, 10,18,160, 1,02,860, and the same have been forwarded to the sanctioning authority after proper verification and scrutiny. It is further stated in the said affidavit in opposition that the amount would be released to the petitioner upon approval of sanction from the sanctioning authority as well as allotment of fund required from the government. Dispose 6 months.
Lordship. Then next is also same lordship, almost non-payment of contractual amount, 39 item number, and that is also admitted by them lordship. So here the materials were spare motor parts in the 39 item. Para 5 lordship, page 21.
It has been submitted. In the affidavit in opposition filed by the respondent number 3 on 23/7/2025, it has been stated the petitioner that from the records maintained in the office of the said respondent number 3 were examined and found that the petitioner had submitted 23 numbers of bills against supply of spare parts, motor parts on various dates, and these bills were in order. It was further mentioned that these bills were forwarded to the sanctioning authority after proper verification and observing formalities to accord approval of sanction against the entitled amount as well as allotment of funds required to credit the same to the bank account of the petitioner. Further to that, it was also mentioned that out of the 23 numbers of bills, the sanctioning authority have already issued approval of sanction against 4 numbers of bills for the month of May, June, July, August, and September 2022. But the allotment of fund could not be provided within the financial year of 2024-25. And as such, the amount could not be credited to the bank account of the petitioner. Further to that, at paragraph number 5 and 6, further to that, the details, the status of the bills of the petitioner have been duly mentioned. From a perusal of the said affidavit, it is clear that the respondents have duly admitted to the amount of rupees 46,40,715 to be payable to the petitioner, and out of which sanction has already been obtained for rupees 12,70,739. Considering the above, the entire amount be paid within a period of 6 months from the
Obliged, Lord. Okay.
Item 40.
considering এইবোৰ আগৰখিনি লিখি দিব তলত. Yes, what is this?
Yeah, Lord, kindly please order the
An appears for the petitioner, appears on behalf of the respondent health department. What is this? Oh, this one, yes.
illegal.
You said out here, if I remember correctly, he will construct there also and here also, so nothing remains.
Your Lord, I have annexed the photograph, page 20 and 21.
I've seen it. But their concern is, as reported by the district authority, the thick-bedded work at Dharmapur SHC is constructing at Dharmapur. According the locality of the area has been informed that the construction of the area is in progress with Dharmapur NC. As thick-bedded is constructing it. So they are constructing in, where do you want?
They want in Dharmapur.
Dharmapur,
They were
Would not,
estimating that
would
when it
also
could be
carry out, yeah. So they are already starting constructing.
30%. That is there.
At Dharmapur, not Dharmapur, your page 20 is, I have annexed the detailed photograph.
Page?
Page 20, your. The construction site photograph I have given, that photograph it is indicate this Patnapati, your. Page 20.
It is a separate project, my lord. With the same work order, there is a.
Separate project already,
that
page
is
20,
Sharpa construction
that
in Patna.
21, I have annexed that photograph also. That is Patnapati, they have already completed 21 and 20, their construction is
Okay.
going on. 20.
You file a short.
Yes, they file a-
Mr. B. Gogoi submits, have placed before this court an instruction to the effect that the 6-bedded ward at Dharmapur SHC is being constructed at Dharmapur NC. However, the counsel appearing on behalf of the petitioner submits that the same be brought on record by filing an affidavit by a competent authority. Taking into account the above, list this matter again on 8th of September 2025. The respondent health department shall bring on record their stand by filing the affidavit. Instruction we could don't keep it. You get another one. The instructions of place is kept on record and marked with the letterings.
Supplementary item 57.
Consumer, the learning council appearing on behalf of the subject of valid affidavit file.
File also, I have also received.
Petitioner got everything, na?
My lord, I am appearing in this case, my lord. I have received my lord, affidavit filed by the my lord. There, my lord saying that admitting, my lord, that's in the item number 57, my lord. Out 8 in the affidavit filed by this my lord government side, and it's there, my lord, sanctioning 8,42,520, my lord, in 2 installment, 1 in 3,000, 3 lakh, 5,42,000.
So you have got 8,42,000.
My lord, I have not get 8,40,000, my lord.
He has received first. Latest instruction yesterday, I have.
Yes, my lord.
Yesterday they have
I have
sent
filed a reply, my lord. On
Mister,
18th,
this has been credited to your account on 2nd of August. When did you file the reply?
my lord, reply today itself filed, my lord. I have filed my lord reply to today.
You say that you have not received on 2/8/2025.
Yes, yes, my lord. On 2/8/2025, I have received 7,36,000, my lord.
7,36,000. How much you are entitled?
My lord, in one bill, my lord, my claim amount is so far, my lord, it is my lord videography, my lord, pertaining to videography, that is my lord 15 lakhs something, and so far my lord conversation of CD, that is my lord 9,55,000. And therefore, my lord, earlier on 18 July 2024, 5 lakhs, my lord 13,000 has been my lord deposited in my account, and I have my lord admitting that that fact in my affidavit, my lord.
Your total amount you are claiming is 9,57,000.
My lord.
Now the question is, of this 9,57,000, one amount is for 2024, 7,14,000.
My lord.
This is for what? 7,14,000 is for what?
My lord, they have only deposited the amount in my accounts, my lord, in 2 installments, but they have not communicated to me, my lord, in respect of which bills, my lord, they are paying this, my lord, disbursing this amount.
I have the latest instruction also, there was no dues proceed. That is.
Dues to নাই কিন্তু সিহঁতি কৈছে মানে 24 দিয়া বুলি লিখে।
You have filed an affidavit.
My lord, I have filed an affidavit.
It has been submitted by the council appearing on behalf of the petitioner that an affidavit in reply has been filed today. The same has not come on record.
Just like there some mistake is there. See, earlier when we have filed affidavit, it is stated that that particular amount was deposited in the petitioner account on 15/7/2024. But actually it was deposited on last 8. My last 8.
মানে মোৰ একাউণ্টত দিতে 2 year ago.
That's why he has no updated. That is the reason.
He has filed an affidavit in repose. The same having not on record, list this matter again on 1st of September 2025. The instructions were produced by Mr. K. Gogoi. It's kept on record and marked with the letter X.
58.
In respect to second case also he has got the process.
Same matter, madam. Same.
First payment.
Analogous matter, madam.
You have filed affidavit
in both the cases.
I'm going to X school. Same order. Yes.
Public.
For order, item 41.
Wait, please, the lordship. As per my last order, I was supposed to file the amended cost elements, but I was not able to file it. I was not in communication with the petitioner. With the petitioner, I was not able to communicate, so I was not able to file the amended cost element as per last order. As per the last order, my lord has directed to file the amended cost type. My lord, when I went to the registry, notarized affidavit has to be filed along with it nowadays, and for that, I have to yes, my lord. For
amended cost title has to be filed by the council for the petitioner.
No, my lord.
It has to be with
a
a notarized
accompanied
affidavit.
with an notarized affidavit. My lord, 2 weeks time may be granted for this, and also they were supposed to file their affidavit.
I was under the impression it can be filed, so therefore I give 3 days, 4 days time. I will see. Okay, 2 weeks' time is being granted to the petitioner to file the amended cost.
Well, they were also supposed to file their instructions. They have,
Yeah, we will kind of will file by Monday.
I've given 2 weeks, which means it will come after 2 years. I think.
42.
highly priced.
In violation of that common order, your lordship, that also killing the party is and we have filed review with concern the institution, your lordship. Review has made dismiss your lordship and we have filed.
Okay, none has appeared for the petitioner. This is the matter of 4 weeks.
Of that.
43.
Well, we have moved the finance melody on 26/6 for release of this 11 lakhs melody that is due to the.
It is submitted by Mr. E. Gogoi appearing on behalf of the respondent contemner that the finance department
PWD
has
has
been
submitted to
moved.
the finance.
Huh?
PWD has submitted to the finance.
Finance department have been moved by the PWD department, by the PWD department for sanctioning of the amount of rupees 11.623538 lakhs, which is the dues payable to the petitioner in taking into the sale document so place is kept on record and marked with the letter X. Taking into account the above, list this matter on 24th of September 2025 for an update.
44.
Not very. 44. None appears on behalf of the petitioner as well as the respondent, for which the matter stands adjourned to be listed after 4 weeks. Yes, 45 to 49.
My lord, page 18, there's a twofold direction. First, to release the earnest money. Second, to after verification.
Has been released, my lord.
No, my lord, nothing has been done, my lord. On last
record
occasion,
here.
the same record they have produced, we inquired to the bank. Not a single correspondent they made with the bank. my
Draft
lord.
number is.
My lord, on what basis they are saying, my lord? Let them show that on what, when the bank, they have sent the record. Whenever the case is listed, my lord, they place this document.
And further, as far as bill is concerned, there is no work done, there is no bill.
My lord, where is the affidavit, my lord? On what
Affidavit
basis my
that
learned
is,
friend is saying, my
if you
lord?
apply the newly, chief engineer, because we cannot file the affidavit if he doesn't include the new chief engineer.
My lord, why chief engineer required, my lord?
Because he'll file the affidavit.
Earlier chief engineer is there, my lord. There is no need, my lord, clarification. Who is the now chief engineer? Each and every time, my lord, the person is getting changed, my lord. But those persons who are holding the post earlier, my lord, they are, my lord, they are bound to file the affidavit, my lord. Nothing has been done, my lord, till date, my lord.
I have the record that says no bill is pending, my lord.
On what basis is saying, my lord?
Verification is being done, my lord. No bill is pending.
Why you are not filing an affidavit?
We can file affidavit, but the technical issue is that if we file the affidavit, this new incumbent has to come and take a lot. He has to file because this deposit warrant is not.
Mr. R.R. Gogoi appearing on behalf of the, which department, PHE? PHE, who appears on behalf of the respondent contemner, is also the standing counsel of the PHE department. He submits that the respondent contemner is no longer holding the post, for which reason he was arrayed as a contemner. And as such, the respondent contemner is not in a position to file the affidavit. As regards the fact that the petitioner, that there is no dues payable to the petitioner after verification, and the earnest money have been duly refunded. Be that as it may, taking into account that there was a direction passed by this court in the 4 repetitions, 4 or 5, 1, 2, 3, 4, 5, in the 5 repetitions, this court directs the concerned chief engineer, which department, PHE department, to file an affidavit placing on record as to whether the verification have been duly conducted, made, and as to whether the is and the result of such verification. So further to that, the said chief engineer, the present chief engineer shall also file an affidavit as to whether the earnest money which was directed to be refunded to the petitioner have been done so.
My lord, only one small prayer.
No more.
Uh,
List the matter again on 15th of October.
My lord, only small prayer. My lord, on 14/5, they have communicated to the branch manager, Canara Bank, my lord, and we have contacted branch manager, my lord. No such correspondence, my lord. Every day, at least to get the money, my lord.
We do one thing. We have it prior to that, 24th of September.
My lord.
File that affidavit. Just file that affidavit.
My lord. All right.
Because once it is on affidavit.
My lord, yes, my lord, definitely.
Yes.
50.
What is it?
50.
Why the matter?
4 and 5.
You are appearing, all of you. Affidavit filed by respondent number 225. We can put it for admission. Nothing on that. List the matter for admission, taking into account that the service is complete.
$52.
Yeah, please, your lordship. Lordship, does the service has to go on respondent number 9 and 10?
We have not taken steps.
No, we had taken steps, but the AD card says that one in respondent number 9 says that he has left. The other, the AD card has not received. Therefore, we appeared in the Lawazima court on 31st of July, and they had placed this case before your lordship for appropriate direction to serve them dusty order. Dusty.
You want to take dusty service upon respondent number 9 and 10?
Yes, my lordship.
The counsel appearing on behalf of the petitioner submits that you would like to take petitioner, na?
Petitioner, yes, my lord.
In WPC number 3415.
Yes, my lord.
Or in the IA.
3415.
In WPC, in the writ petition. To effect service upon the respondent number 9 and 10 by way of dusty.
Yes, my lord.
First up. Accordingly, this court directs the listing of the incident with petition. Urgency is there?
No, yes, my lord. Yes, my lord. Urgency is there, my lord.
What is the urgency?
Okay, my lords, whatever falls from your lords.
On 3rd of November 2025.
My lords, one day after that, third there is another case in civil court actually, my lords.
Huh?
There's another case listed actually.
Where?
My lords, in another court.
You are to do dusty service.
Yes, ma'am.
3rd of November 2025. The petitioner is directed to effect dusty upon the service upon the respondent number 9 and 10 routed through the registry of this court, file file an affidavit of service on or before the next.
You can record my name. But if I appear for respondent number 1 to 4, Lordship, we have filed a objection. You can record.
What?
Lordship, we have just informing the file the objection.
Objection for what?
Lordship, in the IA.
What is this IA business?
Lordship, for stay, Lordship.
Stay of what?
Lordship, actually, they are employed in APG sale to contractual basis, Lordship. Their contract period has been over, Lordship. It's over.
Is it stay?
Lordship,
No, my
there is no stay.
Counsel appearing on behalf of the respondents number 1 to 4 submits that the affidavit is relational. 53.
I'm so obliged.
53.
Service is not complete.
Not complete, but my lord, we have taken steps in the month of April. May I pray one thing, my lord? Can it be listed after a week along with the report of Lawazima court, my lord? Then we may be dusty, my lord.
Where is the respondent?
Respondent this poor, my lord. What?
Effect service by way of dusty.
My lord.
The counsel appearing on behalf of the petitioner submits that the petitioner would like to effect service upon the respondent, sole respondent, by way of dusty, taking into account that the service was already taken on in the month of April 2025. Taking into account the above, list this matter on 3rd of November 2025. The petitioner is directed is given the liberty to take steps upon the respondent by way of dusty routed to the registry of this court and file an affidavit service on or before the next.
54.
My lord, may I pray in the month of October, my lord, any date?
October.
My lord.
You want it on a vacation?
No, my lord.
Okay, 27th October.
I'm-
What is this?
Contempt proceeding. Contempt proceeding.
Contempt for what?
Contempt for
Enter
non-payment
appearing
of.
by filing wakalat number. Who is appearing for respondent number 1?
For respondent number 2, I have a truck.
You are paying for
Respondent number
2. And we are paying for 4? Okay. Now what has happened?
Lordship, here we have the amount, some amount has been paid and some are in the process.
File an affidavit. Bring it on record by way of an affidavit. Come out there, no? If you have complied in the entirety, then it's okay. But if you are not, then file it an affidavit when you are going to do it. Counsel appearing on behalf of the respondent number 2, 4, and 5. Who is appearing for 4? Okay, 2 and 5 submits. Appearing on behalf of respondent number 2 submits that certain amounts have been paid to the petitioner. However, some amounts, the process is ongoing. So this court is of the opinion that said aspect be brought on record by filing affidavit. List this matter again on 10th of November 2025.
Item 59.
Regarding dusty service upon 3-4 has been filed by the petitioner.
Lord, regarding Dusty, my lord, affidavit has been filed. That
give me
is
the
on
file.
record, my lord.
Issue notice. Oh, Musalpur.
Yes, my lord. Mosolpur, Daikuli
Will be
market.
the dusty file.
It was filed on 7/8/2025. It is set, my lord, it is on record. 7/8/25.
This court have duly taken note of the affidavit of the state, so filed on behalf of the petitioner. And more particularly, the contents of paragraph number 3, whereupon it is seen that the respondent number 3 had accepted the notice on behalf of the respondent number 3, 4, and 6. As regards the respondent number 5 and 7, they have refused to accept the notice which is stated on affidavit. Executive officer has refused.
Yes, ma'am. It is from BTC, my lord. Some officer is like that, he refused. That I have nothing to do.
Considering the above, this court directs the instant writ petition to be listed on 28/2025 for admission.
But
On which date this court shall consider the interim plan.
and today your lordship directed that this comparative statement may be produced, but none is there, madam.
Therefore, I can't do it. So on that day, we do it. You are appear for director, Mr. Lakuboy, kindly see this. This person, Executive Officer Musalpur Municipal Board, will be under the government.
It's another government.
You just find it out, please, if you have a copy of the petition.
Will do.
This person, respond number 5, he did this. So ask him to produce we have directed on the last occasion, you give a copy to him.
Yes.
Well, to produce the comparative chart. Because I have not granted the stay because I'll just hear him first. But if they are not done it and he has not accepted it,
I'll do.
on which date this court shall pass appropriate order, consider for admission as well as for consideration of the intemperate.
Then lordship, instead of 20 lordship, 22 lordship.
22. Okay.
10 lordship.
20. Mr. K. Gogoi, who appears on behalf of the respondent number 2, 1 and 2,
Lordship, I'm for one.
respondent number 1, shall also intimate the respondent number 5, who is the executive officer of Musalpur Municipal Board and is a state government employee, about the order passed by this court on earlier first order. The first order I passed,
37, 25.
37, 2025.